And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. We are self-evidently hearing argument this morning by video conference rather than in person due to the ongoing pandemic. The rules of argument are the same here as they are in the courtroom, which is 15 minutes per side with no rebuttal. We have read your briefs and are familiar with the facts of the case, so if you like, you may just get straight into your argument. That's my suggestion, but the time is your own and you may each do with it as you please. The first case we will be hearing today is number 19-729, Commonwealth versus Gonzalez, and I believe we will hear first from Attorney Driscoll.
Good morning, and may it please the court. William Driscoll for ANIBAL Gonzalez. What the trial court left out of their analysis, mistrial analysis, was a case of Commonwealth v. Tad T. Yes, the jury are instructed and presumed to follow those instructions. However, Tad T tells us that a compelling showing of prejudice, irredeemable prejudice, will void that presumption. And that is what was present here, because the drug dealer comment was bad act evidence. And as Creighton tells us, that is the most prejudicial of all evidence. The judge found it was totally inadmissible and had no place in this case. And he also found it was very prejudicial. So it was not coming in at any rate. However, the jury heard that. And the reason why the jury could not disregard that.
Didn't the judge actually say when he came back in after thinking about it a while, you know, a case could be made that this could become admissible under some circumstances?
Yes,
So to some degree, he changed his mind about his earlier comments about it totally inadmissible. Wouldn't you agree with that?
He changed his mind, but for an invalid reason. He claimed that it could come in as bad act evidence to explain the victim's state of mind at the time. However, bad act evidence, as Creighton tells us, is highly prejudicial and inadmissible. The standard for admission is higher than any other type of evidence, as Note 27 tells us. And so it could not have come in as evidence, bad act evidence, as the judge had
It
thought.
didn't come in any event, and the judge issued a curative instruction. And I assume we don't have, I hadn't really thought it through, but I don't think we have enough in this record to determine that it was actually admissible. But my question is, the judge then gives a curative instruction falsely stating that your client, or not your client, that your client was never charged with any drug crime. That's a pretty strong curative instruction. Why is it inadequate? Leaving to one side the falsity of it, which I really don't like, but which isn't the issue here. I don't like judges. I don't think judges should ever lie on the bench, but the judge did say he's never been charged with a drug crime. That's pretty good, isn't it?
Well, it is a strong statement. However, it is not a statement of complete innocence of drug dealing. Drug dealers, by their nature, do not want to get caught. And the best drug dealers are not caught, they are not prosecuted, and they are never found guilty. So that statement by the judge does not automatically clear the prejudice of being called a drug dealer in front of the jury. And Amadeus tells us that bad act evidence is particularly harmful and extremely prejudiced in cases of child molestation prosecutions, as was this case. The jury could very easily say, this guy's a drug dealer, of course.
Now, the jury also, my recollection, it's been a little while since I read the briefs, but my recollection is the jury parses the crimes pretty well, right? They don't convict the defendant of everything, which if they were overwhelmed by emotion and hatred, one might have thought the point would be they aren't really focusing on the crimes. They're focusing on the character of the defendant. What's your response to that?
Well, as I would like to credit the Commonwealth's brief for noting this as well, that the jury heard the evidence and provided the correct assessment based on that evidence by acquitting him of 2 charges, because there was no evidence that his finger or tongue actually penetrated the girl. So he could not be found guilty as a matter of, on a factual basis. So the jury made the right call. But the problem is that the prejudice of being called a drug dealer weighed in saying whether, is he guilty of these other crimes? Well, more likely than not, if he's a drug dealer, he's probably guilty, because credibility was the sole issue here.
We don't have anything that suggests, just because she says it so doesn't make it so. So just because she said he was a drug dealer, there was no other evidence that supported that he was a drug dealer. There was no comment as to any kind of drugs, to any cash flow. So if they were able to discredit her with respect to 2 of the indictments, how do we know that they even considered the fleeting drug dealer reference?
Well, that is the question for this court. Are you convinced beyond a reasonable doubt that that prejudice did not affect the verdicts? And our reply is yes.
Well, you say beyond a reasonable doubt only because you argue that this is a constitutional violation, right?
Yes, it was not a fair trial if there was not an impartial jury.
Well, why would we say that this leads to an impartial jury? And do you have any case that suggests that? Just because some evidence went in that you say is prejudicial, you say that leads automatically to an impartial jury?
Well, it was highly prejudicial under Creighton.
Sorry?
It was highly prejudicial under Creighton. And although not admitted, the question is, would the jury be able to parse that from their mind? The Commonwealth's case throughout
So
the
if
victim
they heard evidence that they shouldn't have heard that was prejudicial, that means it's a constitutional violation? Is that your position?
In this case, yes, because the Commonwealth's thread throughout all 3 witnesses was the fact that Mr. Gonzalez was always around the house. He was always there. The elephant in the room throughout the entire trial, even after this instruction, with the following 2 witnesses, was why was this guy around the house? Why was he not working? Why was the mother supporting multiple children?
I'm sorry to interrupt. I didn't understand this argument at all. The elephant in the room argument. Later on, at least, I know at this point there hadn't been this testimony. Later on, the mother, I think it is, testified that the defendant didn't work. The testimony just makes it sound like his job in their family is babysitter. Now, I understand someone might think to themselves, the judge apparently did, anyone might. I wonder how come he's babysitting instead of working. But that's not what the case is. That's not like the elephant in the room, like, how did he not get caught? This may explain why he's able to be free all day, but it doesn't really go to the elements of the crime. It might it might stick in the jurors' minds because they're trying to figure out the whole story, and this might be a piece of it. But I don't understand when you say the elephant in the room, why this is. I understand why this is bad. I understand it's bad character evidence that shouldn't come in, but I don't know that it's what the case is about.
Well, it's what the Commonwealth's case was about. I referenced many sites to the first witness, the victim's testimony before she called him a drug dealer, where she kept bringing up, he's always around the house. He's always there.
He's
I
the
can't get away."
babysitter. Isn't there testimony that he cares for the children?
The testimony is that's about all he does, is hang around with children.
Right, and so surely, honestly, counsel, when you make this argument, and we don't have to resolve whether this evidence is or is not admissible here, I don't think, because of the case law, but you're making an argument for why it's relevant. It's relevant what he does for a living, because it tells us whether he had access to the children and why.
But it's, even if it were relevant, which the judge found it was not, under Creighton, it was inadmissible because it was more prejudicial than probative.
And maybe so.
Can I go back briefly to Judge Englander's question for you? You think the standard is not abuse of discretion as to whether a curative instruction was adequate or not? You think that's a harmless beyond a reasonable doubt question?
No, the prejudice. The prejudice is harmless beyond a reasonable doubt. But the error.
But the error
abuse
is
of discretion.
this not a mere evidentiary error?
No,
Evidence
because
comes in that shouldn't come in, right? The judge, or maybe it's not evidentiary. The judge strikes it. Okay, so it's so far no error, but there's might be prejudice from it. So you request and receive. I don't know if you requested. Maybe you didn't request a curative instruction. Maybe you requested a mistrial. But there's curative instruction given instead of a mistrial. Isn't that judgment? Do I give a curative instruction, or it's no? That won't be any good. I have to declare a mistrial. That's not an abuse of discretion question.
Oh, that is an abuse of discretion question as to whether or not a mistrial should have been allowed.
Okay, so why isn't that the end? That's what we're. If it wasn't an abuse of discretion.
Oh, I'm saying it is.
Yeah, but I don't understand how we get to harmless beyond a reasonable doubt. That's all. Maybe I need to look at the case law again.
Okay, the judge found that it was the elephant in the room without using that term. The judge found, and
also presumably found, that his curative instruction was adequate to eliminate the prejudice. And so now, but is that a legal question or a question of constitutional law? A question of, what is that?
well, the question here is whether relying on the case law that says that jurors are presumed to follow instructions, therefore an instruction can eliminate all prejudice and all harm.
He didn't know. That's a little bit of a mischaracterization. He says it could eliminate any prejudice or any harm. When I read that in context, he's not saying, I have discovered the magic curative instruction. I can give this at any time and any prejudicial evidence will be cured. He's saying any harm from this error.
Yes.
As I read it. Well, I don't know how much harm there was from this error. He thinks however much there was, this is enough to cover it. And I'm still trying to figure out what the standard of review is, because you've said harmless beyond a reasonable doubt.
The standard of review for the error is abuse of discretion.
Okay.
Finding error, we now take a look at whether the Commonwealth can show that
it was harmless. I see. And you're saying this is not an ordinary case where mere prejudicial error, if you can show non-prejudicial, it's okay. You say it has to show harmless beyond a reasonable doubt, because if there was error, if there was an abuse of discretion, it's a constitutional error.
yes. And what I'm looking for is...
Counsel, if I might interrupt, you don't have a single case where someone has held, in a court in the Commonwealth, an appellate court in the Commonwealth has held, that once a curative instruction is given and the judge determines the curative instruction is adequate, where an appellate court has overruled that and said that a mistrial had to be ordered under the circumstances. Isn't that true?
That is true.
Okay.
And I'm looking for a change in that so that not all instructions are going to be deemed.
Well, I think that's a leap, counsel. I think, yeah, you need to look at every case.
Well, that's what Tad T tells us.
Tad T suggests that there could be a case where the prejudice is so obvious that even though the judge thinks that he's cured it, he didn't. But Tad T itself is not such a case where that happened. And the decision in Silva, which is only about 2 years old, goes through this and explains why, right?
It does. However, that takes a look at the cases that are constitutionally based as far as a co-defendant testimony, and they're not being.
The line of cases is the one line of cases where judges have said, you know, we don't think a limiting instruction is good enough.
Correct,
Right?
but I think that this Commonwealth should learn from the Freeman case and Zuback case in Florida and provide that, yes, bad act evidence, when harmful enough, cannot be overcome by a mere instruction and a mistrial's order.
You're not suggesting that all drug dealers commit sexual assaults, are you?
I see that my time's expired, but no, I am
Answer.
not. However, as I cited in my reply brief, it is a very common theme in today's media that drug, sex, rock and roll. I mean, it goes on and on. You know, drug dealers.
Well, okay,
are
that's not
criminals.
exactly drug child molestation and rock and roll.
All the drug reference in large part did was provide opportunity. And you're not suggesting that there was no opportunity for him to commit the offense, are you?
I am not. Only that the reason for that opportunity, okay, he can be a babysitter, but if he's there because he's a drug dealer doing illegal things and drugs leads to guns, sex, sexual.
I get it. And the judge told the jury, he not only has he never been charged, he's certainly never been convicted. Instruct that fleeting reference. There was no other evidence about any drug dealing, was there?
Well, it wasn't fleeting because it was the Commonwealth's thread throughout the entire case.
Was there any other mention? Was there any other mention other than that sole singular incident? Was there any other mention of drug dealing?
No, Your Honor.
Okay, your time has expired. If there are no further questions, judges, no, you're all okay. We will hear next from you, Mr. Steinfeld.
Thank you very much. Good morning. May it please the court, Kenneth Steinfeld for the Commonwealth. A mistrial obviously is an extreme remedy that is unwarranted in this case. All this case requires is a straightforward application of an impeccable line of cases. Here, the judge showed a keen and comprehensive awareness of the potential for prejudice, and he crafted what he believed to be an instruction that would cure that prejudice. He should not be punished for stating on the record his concerns and the extent of his concerns that there might be prejudice. I'd like to point the court especially to one part of his instruction that I have not seen elsewhere that I think is very good and perhaps ought to be adopted. He said it would be grossly unfair to him and a violation of your oath as jurors if you allow yourself to give any credit whatsoever to the stricken statement. I have not yet seen that formulation, but I think that is an outstanding way for the judge here to tell the jury that they would be grossly unfair and violating their oath. I don't think he had to say that. I think it was otherwise necessary, but I don't think that there can be any doubt that the instruction he gave has been held time and time again to be satisfactory.
Did the judge consider whether the witness was trying to do it on purpose?
Pardon me?
Did the judge consider whether the witness was trying to do that on purpose?
Yes, he did. He found, as a matter of fact, and both parties agreed that she was not, that she did not intend at all to put anything prejudicial into her testimony. And there was a reason later.
I know he found the prosecutor. I know everyone absolved the prosecutor.
Yes, the judge.
Did he also absolve the witness?
Absolutely. He said she did not attempt to influence the jury. She absolutely did. He found that she did not do that. Both the parties and I can find it in my brief if you like, but
That's all right. I'll take a
We'll
look.
find it, yeah.
yeah, no, it's definitely, yes, if you look on page 22 of my brief, the second full paragraph. First, repeating myself to some extent, I think it's clear that the prosecution did not purposely solicit the admissible evidence, nor do I find that the victim was making some calculated or volitional decision to introduce a prejudicial and inadmissible accusation before the jury. So he clearly held that nobody was at fault. And as a matter of fact, as I note in a footnote, there was a reason why she gave the answer that she did, that the jury never knew. She started to talk about him being a drug dealer because she had been asked, did he say anything to you? And this is in reference to the first time that she performed oral sex on him. What she was going to say is that he would throw money at me while I was performing oral sex.
I saw that. How do we know that? Where's that information from?
That's a representation made by the prosecutor to the judge and defense counsel outside of hearing of the jury. She said, I spoke to my witness and she explained that's why. But the judge made an explicit finding that the witness made no attempt at all to throw anything, throw any wrench in the works at all. That there was no misconduct by anyone.
He went further than the language you quoted. He went on to say, I don't think that it was a calculated effort to prejudice the defendant in the eyes of the jury. So, I mean, can you get any stronger language than that with respect to whether or not intentionally did it?
No, I don't think so. I think and both parties agreed. And
the absence of intent is obviously one thing. If there were intent, we'd be in a different situation. But the absence of intent doesn't really tell us how prejudicial this was. And presumably, one can imagine a situation where the testimony is, you can imagine some case where the testimony is, when he was convicted for the other murder, I remember him saying, this isn't going to stop me, right? And you can come up with whatever curative instruction you want, but that, right, it's this, that's a problem, right? That may not be curable. We can come up with something, even with it would be a violation of your oath for you to think about the fact that he has already been convicted of another murder and now is out and charged with a murder. That may not clear it up. So why isn't this that case?
Well, there is a case that I cited in my brief, and I forget which one, where there was testimony that the defendant said, I got away with it before. That was struck, and the jury were told to disregard that. And the judge did not declare a mistrial, and the SJC held that it was not an abuse of discretion.
What was the crime? Do you remember?
I'm sorry, I forget. I think it was murder or some sort of homicide.
All right.
I do not forget the facts of each of it. I just know there was one that I cite that says I got away with it before. And there's all kinds of cases that I cite where things as bad as what you just said have been held not to mandate a mistrial. And of course, it doesn't matter whether she intended or not. The jury heard her say it. If she had intended it, then I think the judge would have acted well within his discretion if he had denied the motion and told the prosecutor, make sure she doesn't say anything like that again. And if that is the case,
but there's the laundry list of sanctions for wrongful behavior that could have been, but that's not this case. This case is just
right. And a declaration. Yes, a declaration of a mistrial in these circumstances, and the fact that it is drugs. All the cases my brother points to that involve prior statements involve similar crimes, sex crimes, very often in a lot of the cases that are more relevant per se, that have something to do with the offense, that a jury could say he has a propensity to commit sex abuse against children, therefore he's more likely to do that here. That danger doesn't exist at all in here because there is no connection between, as you stole the line that I intended to say, Your Honor, sex, drugs, and rock and roll is not child molestation, drugs, and rock and roll. There's no connection. I'd like to go back to something that Justice Englander said earlier, I don't think that the judge, I don't think that he changed his mind as to whether or not the evidence was relevant. He first said this is absolutely not relevant, and then afterwards, when he came back after his break, he said, I can see a scenario in which it might be, and he spoke about if the victim were afraid of him because he was a drug dealer. So he was just speculating that there might be a case in which such testimony about him being a drug dealer might be
Well,
relevant.
we don't have to resolve that, do we?
We don't have to resolve that issue. I'm just
I
saying.
mean, I think what he said is, he said after he came back was that it might be admissible.
Yes.
But I don't know that anyone, early on when he said it's totally irrelevant, it seems relevant to me because as everyone points out, what he did so that he had access to the children, it seems to me is relevant. But if it turns out that what he was doing was drug dealing, sure, I can see a 403 that excludes that. Seems to me to make a lot of sense, but that doesn't mean it's irrelevant.
Sure, but he found that it was, and neither party disagreed with him. So that's the record we have. And I think, as you say, it does not matter. I mean, the jury heard what it heard, and he said what he said. Also, I'd like to agree with Justice Englander that there is no constitutional violation here at all. The standard is abuse of discretion, and if so, because the error is preserved, the defendant would have to show that he suffered prejudicial error. Now, I think it's very interesting. The Florida case that my brother cites, Freeman, the law is very, very different down in Florida. I was actually very surprised. If you look at Florida law, when the jury is exposed to extraneous evidence, the state then does have to prove that it was harmless beyond a reasonable doubt. So it is a very simple matter of saying the law in Florida is so different than the law in Massachusetts.
What's your best citation for that being the standard where the question is something wrong has come in, a curative instruction has been given, and it's inadequate, that it's a question of prejudicial error or not, harmlessness beyond a reasonable doubt? Do you have a case for that?
No, but I'd have to rely generally on Randolph and the standards of review set in there. And I know that's a very general answer, but that's basic principles of standard review.
Pretty
but
sure
it's certainly not beyond a reasonable doubt.
Was simply abuse of discretion.
Right, but if the court had found an abuse of discretion, it said none. But if it had found one, it did not, I don't think, go back and say, well, okay, once we have the abuse of discretion, we still have to deal with the issue of prejudice. And whatever it is, it is not beyond it's not harmless beyond a reasonable doubt, because if it was, then you would basically constitutionalize all erroneous admission of evidence, which is clearly not the case. And I don't think that the Supreme Court has ever even said that the admission of prior bad acts is unconstitutional. It is a
Well, it's an evidentiary question, Jim.
yes, it's a judicial right, but it's a rule of law the judges have come up with to decide what is fair and what's not. But it's not per se unconstitutional to admit. I mean, if he had if she had said that on a previous occasion he did this to other girls, then it would not be an automatic violation of his constitutional rights if that evidence had been admitted. It's just not a constitutional issue. It's an evidentiary issue, as the court says.
Well, in fact, we sometimes allow in evidence like that, depending on how close it is in terms, I mean, it's a discretionary decision on that score. And surely it's not a constitutional issue as to whether or not what might be relevant to a jury in connection with a particular charge.
Well, they were told, yes, that's correct. And they were told that it is not relevant here at all. Strike it from your minds. Do not consider it at all. And
well, presumably, I don't know if we're all in agreement, but something could rise to the level of rendering the trial unfair. Some piece of extraneous evidence could be so could so damage. Isn't this the 42nd burglary that you've been charged with, and you've been convicted of the other 41, and that's your whole business or whatever? And you can imagine someone putting in something so terrible that it does rise to that level. But an ordinary, we'd have to find both an abuse of discretion and a constitutional violation, right? Both that it should have come in, or that this was not good enough, and that it rendered the trial fundamentally unfair before we would do, right?
I always think of my favorite law school hypothetical. I took evidence from Dean Mark Rubin at BC Law School, and on the first or second day, he postulated, what if a man has killed 4 wives in his tub and has been found guilty 4 times of killing his wife in a tub, and it happens the 5th time? Do you let in evidence of the prior 4? And he said the answer is absolutely not, because there's no possible way that if he didn't do it the 5th time that he could ever get a fair trial, which I think is obviously way, way, way beyond where we hear now. But of course, there are circumstances in which it would be so inflammatory, so explosive. If there's evidence that came in that he was a part of, some terrorist group, or had done something just a part of the Boston Marathon bombing that had nothing to do with the case, that would almost certainly need a mistrial. But this case is a fleeting reference to him having been a drug dealer, which had nothing to do with the charges here. And if the members of the panel have no further questions, I'll be happy to rest on my brief. And thank you very much.
Thank you very much. I don't see any further questions.
And we are live.
Thank you. Good morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Desmond and Englander. We are obviously meeting by video conference rather than in the courtroom due to the ongoing pandemic. The rules of argument are the same here as they are in the courtroom, which is to say 15 minutes per side with no rebuttal. We have read your briefs and are familiar with the facts, and my recommendation is that you just go into your argument, but it is your time and you may do with it as you will. We will hear now number 19-609, Commonwealth versus Sylvester. This is, I remind the parties, this is a partially impounded case, so to the extent that the impoundment order applies, I trust counsel to comply with it. And we will hear first from Mr. Suchecki.
Good morning, Your Honors. Today we're challenging the sufficiency of the evidence in the indecent A and B conviction of Mr. Sylvestre. This is one of those cases where the facts equally sustain 2 inconsistent propositions. And in this case, the stories, one sounds more believable than the other. And there's so many things wrong with the complainant's case that I'll first go through the complainant's issues.
Well, before you do that, let me ask you this question, sir. This case at bottom really is about the credibility of the witness. You agree with that?
Yes, Your Honor.
And if we don't consider the defendant's case and only consider the victim's testimony, is it your assertion that there wasn't sufficient evidence standing alone in that testimony to convict?
I'd say based on the evidence that the Commonwealth put forth, there's not enough for a conviction for what Mr. Sylvester is convicted of. In this case, the complainant had a number of contradictions. I'm going to go through the entire case because the most important thing to realize is the Commonwealth still has to prove their case beyond a reasonable doubt. And even in the light most favorable to the Commonwealth, the facts taken as a whole do not sustain that. So
this was a bench trial.
Yes, Your Honor, and even more so in this case because you would think the court would be more savvy in terms of looking at the facts and applying those facts to the law. In this case, the complainant lived in a a three-room apartment where there's a front room and 2 bedrooms and back and a kitchen. In that apartment, she had 3 siblings and her mother and father and a grandparent staying with her. So there are 6, possibly 7, because the mother testified that the paternal grandmother was also staying with them. So on direct examination, the complainant said that she didn't remember who was home that day when the incident occurred. And on cross-examination, she concedes perhaps her maternal grandmother was there. On direct examination, she says after the incident occurred, she left the room and waited for her mother. On cross-examination, she says she actually took a bike ride to a church, talked to her mother there, and her mother said, "I'll talk to you later." And then she goes back to the house and waits for her mother. And when her mother arrives, she says, "Mommy, Daddy harassed me today." Again, during the whole fact pattern, there are a number of issues with that just they're odd or don't strike or are not consistent with a typical case of this kind. Furthermore, so
I'm not sure what that means. When you say not consistent with a typical case of this kind, what does that mean?
Having done a number of these cases over the years, there's certain plus factors, which I'll address in short order, that go with the case. And in this particular case, even talking about the actual, her telling of the incident, she said that she was fully clothed and he called her in a room and he touched her breast. On direct, she says he touched her breast over the clothes and her vagina under the clothes. And then on cross, she remembered that during the same interview, she actually said that he touched her between the sweatpants and underwear. So different than what she said on direct examination.
Your contention is that that evidence has to be essentially ignored at the appellate level. That she testified, he touched my breast. She testified, even on cross, she testifies, he touched my vaginal area above panties, below clothes. That's enough, right?
No, Your Honor, because you still have to
What
prove.
What case says that?
This case has to be proven beyond a reasonable doubt. And the whole fact pattern, and I'll go through it with you. The whole fact pattern has so many holes and there's there's 2 stories here. Then one's more believable than the other. And the fact pattern of the actual incident is less believable than the fact pattern that doesn't support that.
I take it you weren't trial counsel. Is that right?
I'm sorry?
I take it you weren't trial counsel.
No, Your Honor, no.
You say there are 2 stories here. Who put forth each story in your mind?
I think that it's just the fact pattern that emerged at the trial. I think the Commonwealth, there's only one, I think it was only one witness called by the defense. So the facts were put forth by the Commonwealth. So it's what the trial judge did with those facts. And it's our contention that the judge did not rationally apply the facts to this case in such a way that that approved it. There wasn't
Of what element is there insufficient proof?
the actual touching, Your Honor.
You don't think that testimony and cross-examination, if believed by the finder of fact, is sufficient at the least to prove a touching of breasts over the clothes and of the vaginal area over the underwear, but under the pants? You think it is not sufficient? Excuse me, sufficient.
I think you can't ignore the entire case as a whole.
I agree.
I think that no. I mean, I'll have to say no because.
Well, I guess you have to say no otherwise. We have lost. I'm sorry. We have lost Counselor Mello.
And we are back live.
We are back on the record in number 19-609, which is Commonwealth versus Sylvester. Attorney Mello, representing the Commonwealth, has had some difficulty with her video feed. By agreement of the parties, we are going to proceed with her in an audio-only mode. Attorney Suchecki will continue to utilize the video feed. We were at about 9 minutes and 11 seconds of argument when we ran into our technical glitch. So we will continue giving Attorney Suchecki the full amount of his time by giving him an additional 9 minutes and 11 seconds. And Attorney Suchecki was answering my question about the sufficiency of the evidence of the 2 touchings. And he was responding about the case as a whole. And just to remind everyone where we were. And there's the clock. If we start the clock, Attorney Suchecki, I'm sorry about the interruption. So my question was, is the evidence, including the cross-examination of the victim, not adequate to support a finding beyond a reasonable doubt of a touching, I think either a touching of the breasts over the clothes or of the vaginal area over the underwear, but under the clothes?
And I was in the process of saying, no, Your Honor, because there are 2 inconsistent positions in this case, 2 equally plausible stories. And in fact, the other story is more plausible than the touching. So usually these cases, in Vasquez, the court said that they would consider accompanying behavior in addition to the physical contact. Now, that's not like a plus factor for constructive possession, but they're factors that are usually indicative of or add a believability factor to the allegation. And some of these factors are just glaring.
I'm confused, counsel, and I apologize for interrupting, but I'm going to go back to Judge Desmond's question, which is, what is the second narrative and where did it come from?
Well, the second narrative is based on the facts, Your Honor. And if I may, I'll lead you to that in just a moment.
Just tell us what it is right now.
Well, the fact is that there's another child in the house, Brianna, who comes to the house from New York. And Mr. Sylvestre is called and said, you've got 48 hours to come to New York and get your daughter, his biological daughter, because the Department of Social Services in New York is going to take the child away unless you come to New York and take the child to your house. So he goes to New York and gets his child. Now this child has comes into the home. She's 11 months older than the complainant. They go to the same school. They share the same classes.
I'm going to interrupt 1 second. So you're suggesting that because he struck her with the belt and then they had this conversation with the guidance counsel that she perhaps fabricated this evidence to support her sister? Is that what I hear you say?
That's where we're at. And Your Honor,
that's a credibility question, isn't it? That's not a separate narrative. It's just a credibility question.
No, I disagree. I think that you can't have two equally
Did the sister testify?
I'm sorry?
Did the sister testify?
No, she did not. She did not. But so as I was saying, in these
cases, evidence came from the daughter and the mother. And correct. Was there also evidence from the guidance counselor? I can't recall.
No.
So just two witnesses, right?
Correct. So usually in this case, she says that while he was touching her, he was asking questions about school for 5 minutes. After 5 minutes, he stopped and he got ready for work, and then she left. And she told police that he was fully clothed. He was not touching himself. He did not say anything to make her feel uncomfortable. He didn't threaten her. He didn't tell her not to tell. He did not tell her to keep it a secret. He did not tell her not to tell her mother. The incident only happened once. There were years before nothing happened. And then 3 years or 4 years before the allegation, there was no behavior such as this. When she left the bedroom, he didn't try to restrain her, and he did not tell her to come back or block her exit. And the 5 years delay in reporting,
you're asking us to say that her story is so implausible that as a matter of law, no reasonable juror can conclude that the part about the touching was true. That's your argument.
My argument is they still have the case. You still have to prove that element beyond a reasonable doubt.
I agree with that. But you're saying ordinarily someone testifying that something happened would be sufficient beyond a reasonable doubt. And this isn't one of those cases but there's documentary evidence that she was in New Jersey that day or something where the case deteriorates or something to the point where it just is, a video of her in a different place, or he was actually in Europe that month, or, whatever. It's not like that. You're just saying that in light of the absence of all this other evidence that one might expect, no reasonable juror could conclude that the touching part of her testimony was true beyond a reasonable doubt.
Beyond a reasonable doubt. Yes. And
So-
usually,
and so
yes,
all of
like I'm
that,
saying,
all of that speaks to the weight of the evidence that the fact finder attributed to those facts, right?
but it has to be, but the fact finder can make a mistake, and it has to be based beyond a reasonable doubt. It's our contention that
Goes
they
to the
still.
weight of the evidence. Your argument goes to the weight of the evidence.
It goes to the what evidence was presented, and you take the cases, you find it, and the facts in this case don't support the allegations. And this, after that,
Construct counsel, the fact finder can make mistakes. Well, actually, the way we do appellate review, as a general rule, that is not a principle of ours.
but
I mean,
they
the
still have
only
to.
time that we're willing to overturn for insufficiency of the evidence is when there is no way that a fact finder could have made that finding.
Right, and I think based on these facts that there's no way they should, because if you connect the dots, the incident, the girl had the complainant had a birthday. On her birthday, there's a blow up. This daughter, this girl he took into her home, starts running, has been running away. The mother admits that she's called the police on her a couple of times because she's afraid she's run away. So he's actually taken this daughter from New York, who had experience with Department of Family Services in New York, obviously, and knows that she can, or theoretically has some idea that they were involved in getting her out of New York. She comes to Massachusetts. She gets involved in this house, and during the course of this, she gets in a fight with Mr. Sylvester. He spanks her, and shortly thereafter, Brianna goes to the guidance department and complains and says that she was abused. And then after she goes to the guidance department, the complainant is called down to talk to the guidance counselor, and from that she gives this fact pattern, and that fact pattern, it came out of the blue, it came out of nowhere. And then after that, there's 251As that come out, and the other problem we have with this is that the first complaint witness was coerced in order to giving her collaboration of the story. This isn't a typical corroboration. This isn't the DCF actually came into her home and said, instead of like 48 hours in New York where Brianna's had to leave, he was told, Mrs. Sylvester was told she had to get Mr. Sylvester out of the house that night. If she didn't, they were going to take all her kids away. And then
After
not only
beating,
that,
this is after the beating or the allegation of the molestation, or both?
both. The first was
What's the problem
the
with
beating.
that? I'm sorry, what's the problem
Well,
with
the
telling
problem,
her that the allegedly violent man has to be out of the house, or you're being negligent? Where's the problem there?
well, what's wrong with that is it's 4 years later that they came into the house. All you have is these bold-faced allegations, and the fact is that the mother literally didn't even say until after the same interview that she said that her daughter may have told her that she had been touched by Mr. Sylvester. Originally, she says that she didn't believe it. She looked surprised. So she didn't find it credible that he did it. And then on that night, they say they'll take her kids if she doesn't kick them out. They tell her to get a restraining order. So she has to get a
Your
restraining order.
suggestion that the mother's confirmation is made up, because boy, that's pretty interesting in light of the detail with which she can, her first complaint testimony matches the daughter's in terms of being at church and who was at church, and that the daughter did come and talk to her. You
Yeah,
suggest the mother made that all up?
I'm not going to say she made it up, Your Honor, but it's not consistent. I think literally, her quote when she was talked about, she said, "In the beginning, I was not even talking to him, Mr. Sylvester, and I was kind of like afraid to talk to him even about financial situation, because anything that I can do or I could do to protect my children, I was ready to do it." And this is what she did. She literally, there's no choice. She was coerced into giving her first.
Was she cross-examined about this? Was it argued to the jury?
It was a judge, Your Honor. So was she crossed on it? Yes, Your Honor. But
She was married to him then. She's still married to him today.
yes, Your Honor.
And whether she agreed with the daughter's statement or not, the husband was still going to be removed from the house. Isn't that true?
She was removed from the house because DCF said, if you don't remove her, we're taking your kids.
Whether she agreed with the daughter's allegation that she was molested by the husband or not, the husband was still going to be removed from the house that evening.
Correct.
So she was. So how was she coerced into agreeing with the daughter if whichever way she believed, the husband was still gonna be removed?
Well, she was coerced because she was threatened with prosecution. She told him that she doesn't get him out of the house tonight, that they're going to take her kids. And then after the same interview, and she's being threatened with prosecution, she somewhat corroborates the story.
All right. So although the clock doesn't say 0, we're past our time. There we are.
Thank you.
Are there further questions? All right. Thank you for your argument. Very well argued. We will hear now from Attorney Mello. Should she still be there? You're on mute.
Muted.
I don't know if we have control of that, or
She may have.
pause the clock, please, or do something. Stop the clock.
I will let you know when we're back, guys.
Thank you very much. Again, my apologies to the court and my brother.
It's not, yes, it's all right. We accept your.
And we are live.
Okay, we are back on the record in number 19-609, Commonwealth versus Sylvester. We have on the line now, despite some technical difficulties, Attorney Mello for the Commonwealth. By agreement of the parties, she will be continuing audio only, although Attorney Suchecki's argument was on audio and video. Attorney Mello was apparently able to hear the entire argument of Attorney Suchecki, and we will hear now from you, Ms. Mello.
Thank you. If it may please the court. The issue in this case is a sufficiency of the evidence. That is the issue that is brought before the court here. And while in the defendant's brief, he talks a lot about the testimony that was given and talks a lot about the inconsistencies, talks about other plausible explanations, and talks basically what he's getting at is credibility. And that is not the issue before the court today. Credibility was an issue for the fact finder. And just because there are inconsistent statements or those types of things, that does not require a finding that the evidence was insufficient. The fact finder, in this case, the judge, was able to observe all of the witnesses, including the complaining witness, the child, was able to observe them giving direct testimony, observe them being cross-examined, was able to hear not only their words, but see their demeanor and hear all of the evidence that came in, whether it was inconsistent or consistent with each other. And it was the fact finder who was then able to make a determination. The issues that are being discussed today are not going to the sufficiency of the evidence, they're going to credibility. And for those reasons, the Commonwealth believes that these convictions should stand and would ask that the court find that. In regards specifically to the Vasquez case that was mentioned, where additional facts can be considered in a sexual abuse case, such as threats made to the victim, sexualized conversation, et cetera, I'd just like to clarify that my understanding of that case is that those factors may be considered. However, they're not required. They don't change the elements of the indecent assault and battery under 14. So if those incidents don't include those particular items, again, that does not mean that the Commonwealth has not met the burden, and that burden being presenting sufficient evidence that any reasonable fact finder could have found the essential elements of the crime. And it's the Commonwealth's position that in this case, that did happen.
Counsel, my memory, and I'm a little vague, unfortunately, is that there is case law from either this court or the SJC that says that the victim in a sexual abuse case, the victim's testimony, if it meets all the elements, is sufficient, does not have to be corroborated, and is therefore overcomes any sufficiency challenge. What would be the best case that we should look at for that proposition?
Your Honor, I apologize to the court. I certainly don't want to misspeak. I am not familiar off the top of my head with that particular case.
Maybe then it doesn't
can,
exist. Okay.
I certainly can present something in writing to the court post-argument.
Oh, that's all right. That's all right.
If you would prefer. But again, looking at the testimony that was provided and looking at what the Commonwealth must prove, the elements of the crime, there was evidence presented to meet each of those elements. Again, the questions that come in is whether or not that testimony was deemed to be credible. And again, that's an issue for the fact finder. And again, just because there is contradictory evidence, that does not, and this was mentioned in the Commonwealth's brief, just because that there's contradictory evidence, that is not a basis for granting a motion for a required finding. And the Commonwealth cited Commonwealth v. Marino, which is a 2013 case, citing Commonwealth v. Mary in 2009. So again, if you have a witness who is providing testimony and you have other witnesses, or that same witness testifying contradicts themselves, that doesn't necessarily mean that the burden has not been met. That does not mean that a motion for a required finding must be granted. If the panel has no other questions, the Commonwealth would rest on its brief.
I see none. Yes.
Shall I begin?
No, the whole thing will happen and you'll have a clock and you'll see.
Okay.
Okay.
And we are live.
Good morning. Welcome to the Appeals Court. We are hearing argument by video conference rather than in person due to the ongoing pandemic. The rules for argument are the same here as they would be in the courtroom, which is to say 15 minutes per side, no rebuttal. I'm Justice Rubin. I'm joined today by Justices Desmond and Englander. We have read your briefs with some care and are familiar with the facts, so my recommendation is that you launch into your argument right away, but it is your time and you may do with it as you wish. The next case that we are hearing is number 19-646, Commonwealth versus Febus, although I am sure that counsel will tell me the correct last name of the appellant. And if the clock is ready, we will hear first from Counselor Vandershelm.
Good morning, Your Honor. May it please the court. James Vandershelm for the appellant Carlos Febus. There's one issue that I have raised in my brief in this case. This is an unusual case for the first complaint doctrine. In the normal case, where the defendant argues that evidence of multiple first complaints was erroneously admitted, the question is whether the repetition of that evidence itself was problematic or was unduly prejudicial to the defendant. The piling on, as the cases say, whether that was problematic. Typically, you have different complaints to different people that were made, typically in close time proximity to each other. What you have in this case is a very unusual case where the first complaint, previewed by the prosecutor in his opening statement, and then testified to by the actual complainant, was a complaint that was made approximately 3 years after the incident. Then we have the mother of the complainant get up and apparently to the surprise of the prosecution, testify that in fact there was an immediate first complaint.
Can I stop you there, counsel? Apparently to the surprise of the prosecution. Was it disclosed in advance or not?
I don't believe so, Your Honor.
Well, it seems to me that that's pretty important thing to know. I don't see any, I read the testimony. I didn't see defense counsel stand up and say, Judge, this is brand new. You know, I have my disclosure right here and this was never disclosed. So are you telling me on appeal, we don't know the answer to my question of whether it was disclosed or not?
On appeal, you don't know. I think absent well, I don't think it is particularly important, Your Honor, to my argument. The bottom line is...
Maybe not. It sure seems relevant to me.
Well, my argument is that, so the jury all of a sudden has this evidence.
Which evidence?
This second first complaint, if you will, that happened to have occurred first in time. And that's an unusual situation. I think if you look at the cases, you don't often, if ever, confront this situation where the...
Right, let's say for a moment, no, I'm sorry, Judge, you go.
So just so we can kind of put things in context, the victim testifies that she's assaulted, and then 3 years after the assault, she discloses it as a result of a bad dream. She tells her mom, kind of at bottom. That's what she says, right? You agree with that?
Yes.
Okay. And then the mom's called as the first complaint witness, and the mom says, oh no, she told me actually when she was 5 or 6. The mom's memory is that, no, it wasn't 3 years later. She initially told me when she was 5 or 6. You agree with that?
Yes.
Okay. And so that's where we have the first complaint. Whether or not you agree with the mom's testimony or believe that the mom, because the mom said it happened right away, the victim said it happened 3 years later, there's some inconsistency there. That's really what we're trying to ferret out to see whether or not the victim is credible. Is that right?
Well, the first complaint, that complaint as testified to by the mom was the erroneously admitted complaint. Because there had already been a complaint testified to.
You say that, but it seems to me that was the only complaint. Was there another complaint?
Yes, definitely.
Well, if you're saying definitely, it seems to me the mother's testimony was that she heard her daughter scream out, "Grandpa, touch me," or "Grandpa, don't touch me," in a dream. You agree with that?
Essentially, yes.
All right. And so you asked her, did she tell you after a dream? And mom said, no, she didn't tell me. I heard her yell it out in a dream.
Oh. Well, first of all, I don't think the actual, for what it's worth, I don't think anyone said that it was during the actual dream that there was an allegation made. In other words, sleep talking. I think there was some...
That's exactly what the mother testified to.
Precisely.
Okay. In any event, I'm not sure. Let me be clear about the facts as I understand them. There were absolutely 2 complaints. There was one that was made according to in time, that was made approximately 3 years after the other. Those are different complaints.
Let me ask you this. And I'll ask your sister about it. I would have thought, and again, I'm not sure about trial practice. I'm not sure whose burden it is. I think ordinarily something is done in limine about the first complaint. You have to get, I don't know if you have to get, that's part of what I'll ask your sister, but the one side says, Your Honor, we'd like to put this in as the first complaint. And the other side says, no, the first complaint was actually just this thing that she said to some guy at some play, whatever, right? And they duke it out, and then the judge says, okay, yes, or maybe they agree, yes, that's the first complaint. Now, maybe here that happened, and the first complaint was supposed to be 3 years later, and instead, but you say we don't have that on the record. Well, I'll ask your sister. Maybe it happened, maybe it didn't. Maybe the prosecutor was surprised, maybe he wasn't. Let's say, or she wasn't. Let's say the prosecutor wasn't surprised, and that in fact the prosecutor deliberately elicited from the little girl the 3 year later story, and then from the mother the immediate story. And let's say that was therefore, because of that deliberate act, that was a first complaint doctrine error. I don't, it's quite complicated to me, but let's say. And you raised no objection. So the question is there a substantial risk of a miscarriage of justice? Do you agree that's the standard? All right. So now let's sort of cut to what I think is the chase. This was incredibly helpful testimony to the defendant. Indeed, instead of merely attacking some nice little girl who the jury is likely to believe, on a silver platter, they're handed a lying mother who they can say, you can say, the defense can say, will say anything, even contradicting her own daughter, just to get the defendant convicted. And this is her scheme and her plan. Indeed, you elicit that on cross-examination. That's your whole, I don't know if it was you or another lawyer, the whole closing argument. It's actually very well done as far as it goes. And you wind up with the prosecutor conceding almost in closing, look, her mother is who she is. Sorry about that. You've still got this little girl making this testimony, and it hasn't been explained to you why she would be lying, even though we concede the mother is. Now you say, but it created a substantial risk because defense counsel had to focus the attention of closing argument on the lying mother, not on the delay. It does seem to me that the defense counsel failed to argue the delay, like failed to square the circle. It may have been tactical, I don't know, right? I mean, you got what you got. There's no evidence that, except inferentially maybe, that this is somehow put in the child's mind by the mother or something, I don't know. I have no idea. But that has to be your hypothesis, something like that. But that's not because of this error. That's because the lawyer ended the argument at the end of hammering on the worst witness presented. Now, maybe, and I wasn't a trial lawyer, but I've seen plenty of, trial lawyers making these tactical decisions. Maybe that's a gift from the heavens. And you just say, can you go beyond a reasonable doubt when the main corroborative witness is obviously lying? So where's the substantial risk of a miscarriage of justice from this, if we assume it was an error?
Well, he can argue, as he did, that this corroborating witness is lying. Okay, absolutely. The question is, I don't think we can assume that the jury is necessarily going to believe that. So here we have. In
this case, the prosecutor said she was lying too.
The prosecutor said effectively she is what she is. This case is not about the mother. This case is about the child.
Yes, I'm not going to fight what the defendant said about the implausibility of the diarrhea visit really being a visit about this. I'm not going to hammer on that. Don't worry about that, because you still have this child, right? You have to show substantial risk of a miscarriage of justice. Now, if the prosecutor had hammered, you must believe the mother and blah, blah, blah. And it's that first complaint that demonstrates credibility. It was the next day. Hey, maybe you have a substantial risk of a miscarriage of justice from the wrong first complaint coming in. But that wasn't the case.
Yeah. I don't think, Your Honor, it is fair to say that the prosecution effectively conceded that the mother is a liar. I do think that there's no question that essentially he said, look, you don't have to pay attention to her. This is about the daughter. But I don't think, all right, part of my argument is that you have to first consider what I believe, that you have to consider the magnitude of the error in evaluating substantial risk of miscarriage.
Can I stop? I'm sorry, but I want to pose a different hypothetical than Judge Rubin's and sort of explore that, because it seems to me that your argument is that the mother's testimony, when it came out, should have been struck. She should have been precluded from testifying as to her memory of the first time she heard it from the daughter. Is that right?
Yes.
Okay. Now, as I read King, let's just slightly change. Suppose that this diarrhea story didn't happen relatively immediately after, when she was 5 years old. Let's suppose it happened 9 months before the other before the dream thing. Does it have to be precluded then? Now we're a year apart. She says, I think it happened, in 2000 and whatever it was. And the daughter says, no, it happened 9 months later. Does that have to be precluded, or isn't that what King says you're supposed to just explore the inconsistencies between the same first complaint witnesses talking about when and how it happened?
I don't know if I don't know where I would draw that temporal line, Your Honor, but I do think you can draw a pretty bold line between someone saying effectively, this complaint was made to me in the immediate aftermath. I mean, she didn't use immediate aftermath, but she was saying this was immediately made. And I do think you could say, another story about something that was said 9 months later is just another complaint. It's a different complaint. It's certainly 3 years. I would say is a pretty easy. I mean, you got to draw a line somewhere. I would say.
Do you have to draw
I
a
would
line
say 3
somewhere,
years
or
is
just-
certainly. I would say it is certainly. I mean, these folks were talking about. These folks were talking about completely. They were talking about different things. They were talking about complaints that were made 3 years apart. I don't know where exactly one draws the line, but I think 3 years is certainly
So in
a
your
difference
view,
enough to
even
say those
even in light
cannot
of
be
King,
regarded as.
sorry, let me just ask the question because I want to make sure I get it. Even in light of King, which suggests that when you have two different versions of a first complaint, but from the same first complaint witness, that's for a fact finder to resolve. You say even in light of that, if they're so temporally different, they're really two different complaints and can't both be used.
Yes. And I also don't agree with what it appears to be the premise that these were in effect the same substantive complaint, just temporally different.
Your time is running short. I still don't know why there's a substantial risk of a miscarriage of justice.
Well, as I was getting to earlier, you have to think about the magnitude of the error. We are always told by the cases, King and all the others, that juries are skeptical of people who do not complain, if they don't know or believe that someone complained in the immediate aftermath.
How did this obvious lie harm your case?
I do not know that from the jury's perspective, this was an obvious lie. I guess this would be my disagreement with you, Your Honor. I don't think you can simply assume that the jury threw that out. I mean, this mother was very emotional she was crying, as you gather from the testimony there. It may very well be that this person, in spite of what you believe on looking at the paper, came off as a fairly sympathetic witness and a person who may have been telling the truth with respect to something she said. And if they thought that with respect to this issue, I think that is a big deal, because this is the type of first complaint evidence that juries really value. We are told by all of the cases. That's the premise of the whole first complaint doctrine.
All right, your time is expired, but are there other questions? No? Sure, all right, very good. Thank you very much, very well argued. We will hear now from Attorney Salois for the Commonwealth, and she may shed some additional light.
Good morning, Your Honors. May it please the court, Abigail Salois on behalf of the Commonwealth. The Commonwealth respectfully requests that this court affirm the defendant's convictions. Let me start by saying that it was the defendant and not the Commonwealth that elicited the testimony that he challenges on appeal. If you look at what the Commonwealth actually elicited from Ms. Romero, looking at pages 54 and 55 of volume 2 of the transcript, it's very bare bones. All she says is that she and the victim were in her room. The victim was 5, 5.5, or 6 years old. And she said, Grandpa did like this and like that, indicating, and she pointed to her butt. That is all. It even lacks specificity as to when the time this happened. She only says that it was the year that I took her to the Great Brook Valley Health Center. However, it wasn't until on cross-examination that the defendant walked Ms. Romero through the complaint step by step. And that was, of course, in an effort.
In front of the Commonwealth was put in front of the jury. I think it's a jury trial, right?
Yes.
That it happened when she was 5. That's inconsistent with what the complainant said.
Well, that's what the complainant said, or, okay, sorry. The first complaint witness being Ms. Romero, that is what she said on direct exam.
Okay,
It wasn't
but
until
you brought out on direct exam of the child that the
Correct.
first complaint was 3 years later.
Yes,
Then
I'm talking about direct exam of Ms. Romero.
Right,
You
but
can talk about whatever you want. I'm saying
Okay.
you first elicited evidence of a complaint
Yes,
3 years later, and then elicited evidence of a complaint immediately.
yes.
I understand that Ms. Romero's said one and the other said the other. Did you in limine seek to admit a first complaint? And when did it supposedly occur? I don't understand how this even happened.
So I understand when you pose that question to my brother. I'm looking here at the docket sheet. There were several motions, and I was not the ADA who handled the trial, and unfortunately, Mr. Garrick, who did handle the trial, is no longer with our office. But from what I can see from the docket, it looks like there were, let's see, 1, 2, 3, 4 motions in limine, none of which were regarding first complaint witness testimony. And judging from the transcript, the conversations, between Judge Wren, Mr. Garrick, and Mr. Bukmirovitz, it appears that everybody was in agreement about when the first complaint witness instruction was going to be given and the like. So I don't have any
instruction was going to be given, but
I'm sorry. I think there was a few questions that were at the same time.
Go ahead, Judge.
No, it's fine.
Well, no, Mike, they may have been in agreement as to the instruction, but were they in agreement or understanding as to what the testimony was going to be? Did they know what had it been disclosed, what the first complaint evidence was going to be?
Again, I don't have that information because Mr. Garrick is no longer with our office.
Is it required to be disclosed?
No, it's not.
It's not required. First complaint evidence is not required as automatic discovery. That really?
Well, they have.
I'm sorry.
Sorry, if I could just going back to, I think what I'm trying to drive home is that what the defendant is complaining of on appeal was not elicited by the Commonwealth. It was elicited by the defendant on cross-examination, that second later in time complaint.
I'm sorry, but that cross-examination, I agree the details came out. And to me, maybe this goes to substantial risk or the value of the mother's testimony. But you brought in evidence of a complaint by the child that could not have been brought in but for King. You can't ask someone, and did you tell someone? Did you tell someone else? Have you been telling everyone the same thing for a year? That's not permitted, but
Yes.
for the first complaint doctrine. So the Commonwealth elicited evidence. First, I agree, it wasn't from the first complainant, but from the child, presumably so that everything would fit together in the jury's mind when that same complaint was described from the person who received it. So you did elicit evidence of 2 complaints. I can't tell if you were surprised or not surprised. I can't tell whether it was permissible or impermissible, partly because you say it wasn't disclosed. So I don't know. It's very tricky for me, I think.
I'm looking at like the first complaint witness is the first person told of the sexual assault, and that witness may testify to the details of the first complaint and circumstances attending to the complaint as part of the Commonwealth's case in chief. So that
Yes,
is
I
what
agree. But you did bring in evidence of that complaint when the child testified. Now, Judge Englander asked a question about what if their memories differ. And I think it's clear we have some cases where one person says, everyone agrees the day, and one person says, I told her in my bedroom, and she says, no, we were in the kitchen. And that's a difference that doesn't limit the ability to bring it in. But in this case, as cross-examination reveals, we are talking about 2 clearly two different incidents. The one testified to by the mother, if it happened, the child doesn't remember, okay? Because the child was asked and didn't mention it. So now it is clearly two different complaints because the mother describes two different complaints to her. She says the first one was the immediate one. So I just don't understand how, I mean, I understand it's odd and the complaint doesn't seem to be piling on, but I don't see how this isn't a violation of the first complaint doctrine. You elicited two complaints.
Looking at, well, there's two different ways I'd like to answer that question because I think there was a few questions rolled into that.
There always are with me.
First, that's okay. So first, regarding the divergent complaints, if looking at page 11 of the defendant's the defendant's brief, he says, after the victim testified regarding her complaint to Ms. Romero several years after the alleged incident, Romero's testimony about a complaint was inadmissible. Judge Wren did a really clear job of instructing the jury regarding divergent complaints. So at page 52 of the second volume of the transcript, he says, one of the limited purposes of the first complaint testimony is to determine whether the first complaint either supports or detracts from the victim's own testimony about the crime. And as we know, in Commonwealth versus Rivera, the court said that some consistency is expected and will often aid the jury in determining whether the first complaint witness testimony supports the victim's story. And the defendant may exploit discrepancies both during cross-examination and closing, which he did in this case. So I guess the second part of your question really goes to credibility, right? Which is at the center of this case. That's what this case is all about.
My question does not go to credibility.
Okay, so maybe I misunderstood. Sorry,
Well,
maybe
I mean,
I
except to the extent that the first complaint testimony is always let in to show whether the claim of sexual assault is credible. And so now she brings in something earlier than everyone expected, which might make the child more credible. But I'm asking why it isn't an error. Maybe I should just ask it the other way. We'll have to figure out if it's an error. If it's an error, do we have to send this back for a new trial?
No. So the reason that I don't, first I'd like to go through the standard of review because the relief is seldom granted under the standard of review that the defendant is faced with in this case. And the court should not grant relief. And so appellate courts review a judge's decision on admission of first complaint witness testimony only for abuse of discretion. And if there's no objection, of course, the defendant must show that an error created a substantial risk of a miscarriage of justice. And I can certainly get to why that wasn't shown in this case. But the court has outlined that relief is only granted when there is an error, when the defendant was prejudiced. In the context of the whole trial, the error was materially influenced the verdict, and when the court may infer that counsel's failure to object was unreasonable. And that comes from Commonwealth versus Hanino, which unfortunately for me, I didn't come across in drafting my brief, but I did come across it in preparing for today's argument. If you'd like me to provide the citation for that, I can do that. It is 82 Mass App Court 489, and it's the 2012 case. And again, it just really nicely outlines the incredibly stringent standard review that the defendant is up against in this case.
I'd like to, I'm going to interrupt you for a second because I have a question.
Of course.
So the daughter apparently or seemingly doesn't remember disclosing this incident when she was 5 years old. And it seemed a little bit, as you pointed out in the record, Mom was saying, you know, she was 5, she couldn't really speak. She was kind of pointing to this, but the daughter didn't have any memory of that. And so the daughter remembers 3 years later when she had the bad dream. The mother says when the daughter had the bad dream, it wasn't as a result of a complaint that she learned about the grandfather's action. It was a result about the dream. She was actually sleeping with her daughter, and the daughter woke up in the middle of the night screaming this stuff. And that made Mom convinced now that perhaps something had occurred and was going to take the daughter to the hospital. On cross-examination, your brother asks the mother, when was the first time you told the police? And in response to that question, the mother says, when she had the bad dream. So is that actually complaint evidence? The dream. Does that constitute another complaint?
I think the dream itself does not constitute another complaint. What would constitute another complaint is if, the mother and the daughter had a conversation after the child woke up, and at that point, the child disclosed to the mother what had happened to her.
And so mom already has this in the background that this happened 3 years earlier, but just couldn't bring herself to conclude that, this family member was engaging this behavior, could not accept it until the dream. And then once the dream happened, she realizes, well, maybe there's something to this. She woke the daughter up, spoke to her, and they went off to the police. Is that enough? Woke her up, spoke to her, and went off to the police. Is that enough to constitute another complaint?
I guess it would depend on what was said when the mother spoke to the daughter. If the daughter,
we don't know that. The record's not clear on what was said.
The record is not clear, and looking at page 63 of the transcript in volume 2, the mother says herself that she's very confused and she's very overwhelmed. So I think that goes back to where is the substantial risk of a miscarriage of justice? Even if the court were to deem that the decision to admit this testimony was an abuse of discretion, let's just say for the sake of argument, the error did not create such prejudice. Ms. Romero's testimony did not enhance the victim's credibility. It did not prejudice the defendant. If anything, Ms. Romero's testimony was more helpful to the defendant than to the Commonwealth. And we can see that in the defendant's closing argument.
Right. Counsel, isn't your brother right? We don't know what the jury credited or didn't credit. The general philosophy of first complaint is to counteract what's perceived to be a belief, which is if you're closer in time when you make that complaint, it's going to make you more credible. And her evidence was that it was almost immediate in time. How do we know that didn't help the prosecution's case?
We don't know that. I mean, we can tell that the prosecution didn't use that evidence at all in its closing argument. If we look at how it was used, it wasn't used. The prosecution, begged the jury to
perhaps
focus on.
It wasn't disclosed, but we don't know. I'm very troubled by the fact that we went through this entire argument without knowing an answer to what I think is a critical question. Was this disclosed in advance to defense counsel? If it were, then I think substantial risk of a miscarriage of justice goes out the window, because there's a darn good chance it was a tactical decision on his part not to raise it. But since we don't know the answer to the question, I think we're at sea, and that troubles me.
I would think, Justice Englander, and of course, I don't have the benefit of speaking with the trial prosecutor about this, but I would say, looking at the transcript, there's no, request for a sidebar conversation or a bench conference to say, wait a minute, I didn't know about this.
If you look at each of the full record in the trial court, including the motions to eliminate, I mean, surely you must have copies of whatever your brother filed.
I don't see the defense arguing that they were ambushed. I mean, we don't conduct trials by ambush, particularly in these type of cases. I can't picture a scenario where the first complaint witness and testimony was not discussed pre-trial. I can't imagine it. And I can't imagine that the defense counsel wouldn't have jumped up immediately and said, wait a minute, Judge, something's amiss here. I just don't see that anywhere in the record. Do you? So to ask a question.
I don't see that anywhere in the record at all, Your Honor. I would just say, finally, looking at this court's decision in Commonwealth v. Dumas, the court said there was no merit in the defendant's contention that he was prejudiced by a violation of the first complaint witness doctrine, because much of the testimony now complained on was elicited by the defendant on cross-examination. That's what happened here. The fact that there was, the mother saying that the child made the complaint at a certain time, and then on cross-examination saying that she made it 3 years later, that was elicited on defense. So the defendant cannot now claim that he was harmed by evidence that he himself elicited.
Okay, your time has expired. Are there more questions, though?
And we are live.
Good morning. Welcome to the Appeals Court. I'm Justice Rubin. I'm joined by Justices Desmond and Englander. We will be hearing argument by video conference today rather than in person due to the ongoing pandemic. The rules of argument are the same as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. We have read your briefs and are familiar with the case, so you may want to get right into your argument, but it is your time and you may do with it as you wish. Our next case is number 19-875, Commonwealth versus CORREIA, and we will hear first from Attorney Goldblatt.
Thank you. The real issue that we're litigating here is whether adjutant evidence expires. That's the heart of what's going on here. The alleged victim, Mr. Guilfoyle, in this case, had a 12-year-old incident of really horrific violence during. I'm sorry, I'm getting an echo.
Before we get to that, is there any dispute in this matter that Guilfoyle was indeed the first aggressor?
It depends what you mean by first aggressor, because first aggressor is defined as the person who initiates any kind of physical combat, and it also encompasses the first person to initiate deadly combat within an existing confrontation. So in this case, there was no issue as to whether Mr. Guilfoyle had been the first person to initiate physical contact. He admitted on the stand that he had punched the defendant in the face, I think. But there was—
And the government concedes that.
Yes, and the government had always conceded that. The issue but whether he was the first aggressor with respect to the initiation of deadly force was very much in play. And the Commonwealth would argue that he was not.
Okay, so can I ask you how it was very much in play? I understand obviously this case started not just with the pipes, but with this shooting. Presumably both of those are deadly force, allegedly perpetrated by the defendant, who was acquitted of all the gun-related charges.
Yes.
So I guess what you're saying is, right, he was charged and convicted of assault and battery with a dangerous weapon. I take it those are these pipes.
Yes.
A dangerous weapon isn't necessarily deadly force. It's force sufficient to cause serious bodily injury or death. But maybe it was deadly force, so that's not a necessary component of this. Where is it that you claim Guilfoyle introduced deadly force, and how would the testimony of a witness to this long ago event, I actually don't care how long ago it was, this serious event before, whatever, how would that have helped the jury figure out who introduced deadly force? And I don't even, well, just maybe let's start with that. What is it that he did that you say was deadly force that the jury may not have realized was deadly force, or was not the introduction of deadly force?
Well, the question would be, at any point from the moment he started the confrontation, had he introduced deadly force? So when he hit the defendant.
It's a self-defense or defense of another claim that's
Yes.
relevant to only, right?
Yes.
And the self-defense, I gather, maybe you can correct me, I gather that there is no self-defense claim with the pipes. It's defense of this third party who's running away, whose shirt was grabbed.
Yes.
So the only force that's been introduced by Guilfoyle is the punch in the face, conceded punch in the face, maybe another punch or two, I don't remember, and grabbing the shirt of the person running away. And then pipes come out.
Yes.
So where is, and let's assume the pipes are the introduction of deadly force, I guess. Where is it that you say Guilfoyle introduced deadly force?
Hitting the defendant Well, let me back up. The question is when he's holding on to the co-defendant and trying to pull him towards him to do whatever he's going to do, Mr. Corrêa has to decide, the defendant has to decide, is he pulling this person toward him to give him a hug, give him a shove, or hit him in the head so hard that he might kill him? And Mr.
Those aren't the
Guilfoyle,
only options. Those aren't the only options.
that's true. There are an infinite number of options at that point. And
So
Mr.
let's go back to Judge Rubin's very specific question, which is, at what point do you allege that Guilfoyle introduced deadly force? You tell me where it is in the spectrum.
when he hit the defendant so hard in the head that he fell down before he hit him the second time so hard that he lost consciousness.
So you're saying we all agree, and it's conceded that that was the introduction of force.
Yes.
You're saying it's deadly force.
Yes.
How exactly does the evidence of this event in the police cruiser shed light on whether that force was deadly or just serious? I don't understand.
It goes to whether the Mr. Guilfoyle, when he is assaulting somebody, is doing it as he described, merely to somehow stop them from doing something bad, or is so far beyond that that he's risking serious injury or death to that person. So
No. That is deadly force serious injury or death, or deadly force means reasonably likely to cause death or something like that. What is the definition of deadly force here?
I don't want to give it wrongly. I know it's in the papers. I don't think it's only force sufficient to kill. It's force that I know it's subjective. So the Mr. Corrêa would have had to decide whether it was possible that it would kill him or possible that it would kill someone else.
Hold on, I'm lost here. I thought the purpose of adjutant evidence was to determine the identity of the person. It was to allow and help the jury to identify the identity of the person who first escalated the contest. That's not what you're talking about. You're not talking about a question as to whether or not Guilfoyle did these things. That seems to be undisputed. You're talking about whether it was in his state of mind, if you will, or in his constitution to be able to do greater harm maybe than was apparent. How does that square with adjutant? Isn't adjutant about identity?
The identity of the person who introduces sufficient force to trigger a deadly conflict.
So you're saying
Yes.
the pipes are deadly force?
Yes, the pipes were.
Pipes are deadly force. And so you're saying in this defense of another, the question has to be, was it excessive to use deadly force or not?
Right.
And if this was a man who had already used deadly force, introducing it into the conflict, it might well be reasonable to think he's holding on to the fleeing third party in order to use deadly force on him.
Exactly, you said it better than me.
Where is the introduction of deadly force? You're saying the punch that knocked him down,
Yes.
in your view, was deadly force.
Yes.
And if only the jury had known that he beat this guy in a police cruiser years before, mercilessly, wrongly, and so on, that they would understand that this guy's punch is deadly.
And he knows it.
Who know? I'm sorry, Justice Desmond. Who knows it? I didn't get the pronoun.
Guilfoyle.
Well, it doesn't matter what Guilfoyle knows. It would matter what Mr. Corrêa knows. But yes,
All right, so
You're
leave that
saying,
out.
does it tell us anything more about the strength of the punch? That
yes,
is, a punch in the head that lands someone on the ground maybe is inherently deadly force. While we've been sitting here, I looked up the definition.
thank
And
you.
deadly force is force intended or likely to cause death or great bodily harm. You don't think the jury already knows a punch that knocks someone down is that kind of force? Maybe they don't, you're saying. But then, I guess you're saying, how are they helped by knowing that he also punched someone else, again, not killing him, but punched someone else and beat someone else before. How does that help with the question? This is an introduction of force, but is it deadly force?
It helps with the question by hearing from somebody who was on the receiving end of that punch and can say whether that punch felt to them like something that could be life-ending. So the person who he punched in the face in the police cruiser, he punched repeatedly. And it wasn't just that he punches in the head, and he punches repeatedly. And he's punching, banging his head against the window. So he's smashing the back
against the window, which is not a punch.
Well, the punch is so hard that it knocked his head against the window, and he kept going even after that happened. So someone who's in a physical conflict with another person who behaved that way, and remember, this is all about the head. It is the idea that you can
knock someone unconscious with a punch in the course of this, doesn't he knock?
But he didn't knock him unconscious with the punch until after the pipes. So the question is, did the pipes start it, and then the only blow that was deadly force was after the pipes, or was that first punch or series of punches already the escalation into the kind of punch that can create a TBI, a traumatic brain injury?
I guess it's not a matter of angels on the head of a pin, but was he punching the first guy? We know a punch from him can knock someone unconscious and can knock someone down.
Yes,
and
Judge.
you're saying, but the first punch might have been brute force, but not deadly force. So they need to know that the first punch was deadly force. It just seems like slicing things, really thin. I'm having a hard time sorting out how important this could be.
Well, I think you.
Go ahead.
No, please.
No, answer Judge Rubin's question.
I think that whether a punch to the head that causes someone to lose their balance and fall down, for the jury to try to figure out, well, was that deadly force or not? I think a lot of juries would say, probably not. You can punch someone, they lose their balance, they're surprised.
Does it matter that no one argued deadly force in closing? The phrase deadly force, I don't think I'd have to look again. I don't think it even comes up in the transcript.
It doesn't matter if it's
excessive force does.
It was in the jury instruction.
Deadly force or excessive force?
Hold on. It was on page 80 of volume 5 of the jury instruction. I can bring it up.
I'll look. But keep going.
So the issue of of how hard he punched and whether Mr. CORREIA fell down because he lost his balance, because he was surprised, or because right from the beginning, this man was so brutal that he initiates a fight with all of the force necessary to cause someone a traumatic brain injury.
Can I tell you something? He initiated the fight with all the force necessary. Right? There's no calibrate. You were having a fist fight. You're not calibrating like, I don't want to kill this guy. I just want to knock him over. Oh, now I want to kill him. You're having a fist fight. He punches him in the head or face. I'm just having a hard time seeing that, and now hearing that he punched someone before, maybe he was calibrating it there. I can't have a dead suspect. I can only have a bruised suspect. So,
may I ask a question? The question is what kind of evidence does adjutant allow? It's a narrow exception that allows some kind of evidence regarding prior conduct by the victim to come in, right?
Yes, Judge, as character evidence.
I think that the way I read the cases, that evidence can only go to the identity of who was the first to escalate.
It's first aggressive. That's what it is.
Under Chambers, and I cited it in my opening brief, if you mean first to escalate, including the movement to escalate to deadly force, yes, otherwise no.
What about Camacho, which you don't respond to in your brief? Camacho, it seems to me, takes care of exactly the issue you're raising here.
Well, Camacho specifically says that it's only relevant to who initiates the argument or who escalated it to deadly force. That's actually quoted in Camacho.
Right, but in Camacho, they rule out the evidence because they say there's really no debate as to who did what. who threw the bottle, who did this. Since there's no debate as to identity, the evidence doesn't need to come in. Aren't we in the same place in this case? We know exactly who did what. Arguing about how much force Guilfoyle was capable of may be relevant argument for a jury, but it seems to me that it's not relevant to the adjutant question. And so I'm asking the question, where am I wrong in my reading of Camacho? Because I just went back and you didn't address it in your brief.
Where you're wrong in your reading of Camacho is that Camacho specifically says that it wasn't addressing, that the adjutant evidence would not have helped address either the issue of who initiated the physical contact or who initiated deadly force. There was nothing to suggest
how does the evidence that you're talking about help us understand what was the identity of the person who initiated deadly force in this particular battle?
It helps you understand whether that initial punch was just a punch, and whether when he was holding the person back, he was pulling him towards him, looking as if he's about to initiate some kind of deadly, whether he looks terrifying and he's about to hit him on the head so hard he's gonna die, or whether he doesn't. I think it's
your time has expired, but he has to believe, according to the instructions, he has to reasonably believe that, I guess the third party in this case, is in immediate danger of great bodily harm or death.
Mm-hmm.
Your hypothesis is being punched and falling to the cement isn't great bodily harm.
Might not be, no. You can be punched and lose your balance. You can be punched and the person, I mean, there's lots of ways to be punched.
We'll ask your brother, your time's expired. Very good argument. And we'll hear now from you, Attorney Doherty.
Sorry, there we go. Good morning, and may it please the court. It's Andrew Doherty for the Commonwealth. I think it's important to start with adjutant or adjutant, and I never heard it said out loud, but the court opened the door for prior bad act evidence to come in, but imposed some important limitations on that evidence that a court would consider before letting that evidence come in. And they did two things. They raised the specter of and concern about raising collateral issues becoming too prejudicial, but also limited the introduction of that evidence to the question of who the first aggressor was. That comes into play here. And Justice Rubin, your questions about whether this was relevant to show that he sort of just to measure the level of force that Mr. Guilfoyle was using, I think runs afoul of the philosophy behind adjutant, which is that it's not there to help the jury understand what happened, but when it happened. I
mean, this is sort of, I take it, what Judge Englander was getting at by saying it's not about identity. We're not using it for identity here. We're trying to figure out how much force was used. But if the question is who introduced deadly force, what is the identity of the person who introduced deadly force, we need to know, well, had this man Guilfoyle introduced deadly force or not? And so I'm not sure why, given that we have this rule that says, I don't know that it makes any sense, but that says that the introduction of deadly force is a new adjutant question. I don't know why it wouldn't be possible, if there were some evidence that bore on that question of a past bad act, to bring it in under whatever, I guess I'll call it adjutant.
I think my concern again is that it's the question is who initiated it, not what was initiated, and that's where my concern about the escalation of deadly force comes in, right? Because the defendant would ask the question. The defendant would measure Mr. Guilfoyle's actions based off of a 12-year-old event. To determine whether he was still capable, I suppose, of using deadly force. The I'm not sure that that's what the court was looking for, and it's repeatedly said in Camacho, for example, that it's really adjutant evidence is solely for the purpose of determining first aggressor, and not measuring the level of force that's used. I'm not sure that that was even in Chambers something that the court talked about. Again, the question then became, who was the first aggressor?
Your sister says, and you know, there's some strength to it where I'm sitting. She says the evidence of the prior conduct will help the jury kind of understand things that might be visible only to somebody who's standing in front of the person who's about to punch them. Let's put it that way. Might be relevant to the defendant and aggressor deciding, this guy's going to kill me. If I don't do something, this guy's going to kill me. And I know it because I can see it in his eyes. What do you say to that?
I see that evidence was already before the jury without bringing in evidence from a 12-year-old event that was not similar to the event in this that was being tried. Both counsels discussed and defense counsel certainly discussed the size differential between the two gentlemen. The fact that he was both, I believe, trained in the Army in martial arts, as well as having worked as a Boston police officer, was well before the jury. How would a one incident, terrible though it was, add anything more to what was before the jury with evidence and testimony to then bring in the character to help the jury understand just what Mr. Guilfoyle was capable of?
That's not an argument that this evidence would always be excludable. That's an argument that the particular evidence that they were looking for was within the judge's discretion to not admit it. Because it wasn't probative enough.
I'll say this. I'm not aware of any case that has expanded adjutant evidence beyond the question of first aggressor. And to hold that character evidence, any prior bad act evidence, is for more than that in a self-defense case, it would be new law. And I would be concerned about that, especially given precedent saying that this is solely for the purpose of establishing first aggressor. Part of my confusion here is, and the court raised the question of deadly force. I reviewed the trial transcripts. Deadly force comes into it sua sponte from the trial judge, Judge Krupp, who, in thinking of his jury instructions, as I read it, is concerned that the jury is going to find that the use of pipes in an overhead fashion, this is on the fourth day towards the end, the use of pipes in overhead fashion, the jury's going to find that that is deadly force and that it wasn't proportional to the force that was used by the victim. And the deadly force instruction was given as a way for the jury to understand the justification of the use of pipes, that even use of pipes, which could be deadly force, has a justification in the law. What the judge didn't do is then ask the question, who initiated deadly force? That was never raised by the defendant. That was never raised by the Commonwealth. So the defendant got the benefit of essentially the possibility of justification for using deadly force, if that's what the jury found, but also the Commonwealth didn't get the opportunity to then prove that he was the one who initiated the deadly force or put that question before the jury. That was never asked of the jury. So it wasn't
a waiver. Are you saying? I mean, this deadly force argument. I think my recollection is, and I think I'm right, that it wasn't raised in terms, at least below. That there was some mention of. I think I wrote it down here somewhere. Who introduced a weapon into the fight is what they said below, not who introduced deadly force, right?
I'm not sure at what stage you're talking about. And part of my concern is this, is that I think we may be losing the forest for the trees, because the challenge to a judge's decision in this case isn't whether the evidence came in, it's whether the defendant was entitled to this evidence.
Yes, but they had to argue to the jury, to the judge, we want to bring in this adjutant evidence. We want this witness's name so we can get adjutant evidence to show who introduced deadly force. Right, that had to have been raised below, right?
Well, and I'm afraid that it wasn't. The question of first aggressor was raised below.
That's what I'm saying, but that's not a disputed issue. So isn't it a waived claim?
I believe that if it isn't, and remember that on the day of trial, defense counsel did say this is not an adjutant issue. I'm not looking for these records in order to establish an adjutant issue. I'm looking for these records to establish his ability to recall and identify things. But if you look at the defendant's filings before the motion judge, all that's really there is an averment that first aggressor is an issue. There's not a question of who was the first to use deadly force. It's just an averment. This is the first aggressor is going to be an issue.
So what's our standard of review?
First it's an abuse of discretion standard, and then because there was waiver at trial, it's whether there was a substantial risk of a miscarriage of justice. And I don't see, given, and again, we're evaluating the motion judges and trials judges' decision not to release this information to the defendant.
And with that, because it wasn't characterized as adjutant evidence, that wasn't the issue at trial. Judge Krupp looked at the prior incident in camera and determined that it didn't touch on the memory and the recall issues that was raised by defense.
And I want to be a little bit careful about that, Justice Desmond, because there were so many different records at play here. And it appears to me on my reading of the transcript that what the judge was referring to was a separate set of records which were withheld from production, 8 or 9 records that were withheld from production because they were exempt from the public records requirement. And those records had never been disclosed to the defendant, had never been turned over to the court until Judge Krupp took a look at them, evaluated, and then made a separate determination based off of the defendant's statement. I'm really looking for these for ability to recall and perceive information.
Is your sister's argument that anytime Guilfoyle punches somebody, that's deadly force?
I think it has to be, because if it isn't, then the defendant really wasn't entitled to a defense based off of deadly force, right? Because he would have been the one to initiate the deadly force by using the pipes. So it has to be one of the 2 incidents beforehand, whether it was the first attack outside of the car, whether it was the attack of his friend. One of those has to be deadly force.
So now you're saying for him to win his self-defense claim, the jury has to find that one of those things was deadly force. Doesn't that undermine your argument here by suggesting that he should have been able to get the testimony from this witness to help the jurors understand, yeah, that was deadly force?
So again, that's not a question. That's not a question of when the deadly force occurred. It's a question of whether it was deadly force. Is the question that they're trying to answer with records using adjutant evidence. And my position is that is not something that adjutant, and it's the case law that it birthed allows that.
And you think that is what Camacho stands for?
I do. I think that Camacho says that is not first aggressor evidence is solely for the question of who was the first aggressor, not to measure the level of force that's used.
And is it also
measure the reasonableness of the response of the person who's subject to the force, right? I mean, when it's a self-defense And the question for the jury is whether among others, is whether his response was reasonable, right? Whether the force that he chose to use was reasonable. You're saying adjutant evidence doesn't go to that question.
That's absolutely correct. It's whether adjutant evidence goes to whether or not the defendant is entitled at all to a self-defense instruction based on who initiated the confrontation or escalation, and that's it. To hold otherwise is to go against. Let me correct that. There's no cases that say that this is appropriate. It really goes to the question of first aggressor.
It's very tricky to me. I mean, I read Camacho, and I won't say it's sophistry, but I have a lot of time understanding what the heck it means to say, oh, this doesn't, this only goes to what, whether who the identity of who introduced it. But all right.
Sure. Well, and bear with me here, Your Honor, because at the end of the day,
I mean, we're bound by Camacho, I guess. I don't.
Bear with me. At the end of the day, the next question is, did the defendant establish that records that involved an incident that was 12 years old have any bearing on a question that the evidence was going to come in?
But it wasn't raised below, so we're looking at substantial risk. I guess substantial risk has to include, if it was properly presented, would it have been allowed in? But they didn't ask for it for this deadly force reason.
Nor that, right. And so just to close that point, I think if you apply the case law to what these records were, you can't find that there was a substantial risk of a miscarriage of justice. And I just ask you to affirm
the defendant got a self-defense instruction.
In both for deadly force and for non-deadly force, yes, without a question of who the first aggressor was.
All right, your time.
And we are live.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by Justices Desmond and Englander. We are sitting by video conference rather than in person due to the ongoing pandemic. The rules for argument are the same here as they are in our courtroom, which is to say 15 minutes per side with no rebuttal. We have read and are familiar with your briefs and the facts of the case, so my recommendation would be to get into your argument, the meat of your argument right away, but it's your time and you may do with it as you wish. The first case we will hear today is number 19783, Commonwealth versus Tobey, and we will hear first from you, Attorney Peterson.
May it please the court. Good morning, Your Honors. My name is Jennifer Peterson, and I'm here today on behalf of the defendant appellant, Mr. Gregory Tobey. As I'm sure Your Honors are aware, in order to prove a prima facie OUI case, the Commonwealth has to prove three things beyond a reasonable doubt. One, the defendant's in physical operation of a motor vehicle. Two, on a public way. And three is doing so with a blood alcohol of 0.08 or while impaired by intoxicating liquor. In the instant matter, Mr. Tobey conceded the first two elements of this crime, leaving the only matter to be determined by the court whether or not he either had a blood alcohol of 0.08 or was impaired by intoxicating liquor. We argued in our brief that the Commonwealth's evidence was insufficient to establish Mr. Tobey's diminished ability, that it was his use of alcohol that caused it. In particular, there was a lot of this, as I'm sure Your Honors are aware. Mr. Tobey was found down an embankment, sitting in his car. He was spotted originally by a DPW worker. That DPW worker asked if he was hurt, and Mr. Tobey replied that he wasn't. The police were called, and about 15 minutes later, when Officer Hines came and asked Mr. Tobey if he was okay, Mr. Tobey responded that he wasn't, that he was having problems with his left side, that he couldn't move his arm. And Officer Hines specifically stated that it appeared to him that there was an injury or redness to his arm, and he called an ambulance. After the ambulance was called, Officer Hines asked Mr. Tobey what had happened. Mr. Tobey said he was experiencing chest pains, so he pulled off the side of the road. And
are you arguing that we know these facts? Are you arguing the evidence is insufficient to demonstrate impairment? Is that why you're going through these facts?
Yes, Your Honor. I would argue that the finder of facts have to be persuaded beyond a reasonable doubt.
Okay, so I'll give you some facts and you tell me why they're insufficient.
Okay.
I mean, I'll tell the story, leaving out some parts that might be more or less credibility judgments, but okay. A guy is found in a truck that was running. He's now turned it off. 20 to 30 feet, I won't go 100, 20 to 30 feet down an embankment against a tree. There's a receipt found in the car that says that within about an hour and 15 minutes of the accident, he purchased 3 of a certain brand of beers, 40 ounces. There are only 2 full ones there and an empty one in the seat next to him with the screw cap, I think, off, but maybe it's on, whatever, it's empty. Let's leave aside the other bottles on the floor. Maybe they're from some other time, although for sufficiency's sake, we should take this in the Commonwealth's favor, but okay. So he's drunk at least 40 ounces of beer. Oh, and he also admits that. He says to the people at the hospital, I drank 40 ounces of beer. When asked what happened, he says, 30 feet down, 20 feet, let's say, down an embankment, I pulled off the road to park. He doesn't say I slipped on the ice or whatever. He pulled off the road to park down an embankment 20 feet, which seems untrue. He claims to have a medical condition, but every time the police encounter him and are going to do something about it, that's what he says. He says it twice during the day. And I guess let's put in, he has a fist fight later at the hospital, although clearly he is, the doctors don't say he seems impaired. I get that. But he has a fist fight later that leads at least one officer to conclude he's inebriated. Why isn't that sufficient?
Well, Your Honor, it's a preliminary matter. I think some of the facts aren't quite accurate. There was one empty can, 25 ounces of a different brand found, just one other.
There's a 40 ounce, I didn't use the other beer. I said he drank 40 ounces of beer, which you or I might know more colloquially as 3 beers and 4 ounces, right? Now, given his history, maybe that's not enough to impair him. It is enough to impair me, but all right. It's right. I mean, people get impaired with 3 beers while driving. And his response to the question, why are you down an embankment against a tree, is I pulled off the road to park. Okay. You don't think the jury could, I'm not saying it's inescapable, could infer impairment?
I would suggest, Your Honor, that they couldn't without speculating. And with respect to the 40-ounce beer, that beer was said to be partially empty, not fully empty. And it's unclear if he did go down the embankment.
He told the doctors, there's an admission to the doctors, I drank a 40-ounce beer.
Yes, Your Honor.
All right, so I'm willing to say he drank 40 ounces of beer.
Okay, so if we're looking at that admission, then you should also credit the fact that he said he was having heart problems. And so if you're going to credit that the reason he pulled off to the side of the road was, this is a person with a history of strokes, a history of cardiac events, and he feels as if he's having a cardiac event. So
is it true that he didn't credit that? Is it true that he didn't want medical attention because it was Super Bowl weekend?
I believe there was a reference made that he said he didn't want to be kept overnight because it was Super Bowl weekend. But with
notwithstanding his heart issues.
Notwithstanding his heart issues, well, he was given nitroglycerin and baby aspirin and the like, and his
medical records indicate that it did cause no change.
Yeah,
now that might be diagnostic for no heart, no angina, but all right. I don't know.
Okay. Well, and there's also the issue of the fact that we don't know when he drank that alcohol. He was down that embankment.
Yes, we do. We know that he drank it between the, or at least inferentially, we know he drank it between the time that he purchased it and the time that it was found in the car, an hour and a half.
And he still had alcohol on his breath.
Well, it was a very faint odor of alcohol, the police officer said.
Okay.
And in addition, we don't know if after he pulled off, he decided to drink. We don't know when he drank that alcohol. We do know
you have to view the evidence in the light most favorable to the
yes, but we also can't speculate or guess. And I would suggest that in order to say,
okay, so here's a non-speculative basis.
okay,
Someone who drove down an embankment 20 feet must have been impaired. I guess he must have drunk the beer in the car between buying it and going down the embankment.
or he could have been suffering from a medical condition that was causing him great pain and concern. And
although you mentioned that to the DPW person, the first person on the scene.
He said he wasn't hurt. You're saying you're not hurt by a DPW, by a tow truck, a plow driver, a random person going by.
Why wouldn't he say, why wouldn't the jury be able to infer that by not saying, I'm having a heart attack, please call an ambulance, that that's not why he wound up off the road?
The burden of persuasion isn't on him, it's
I
on the
agree.
Commonwealth. And I would suggest that it's on the Commonwealth to prove their case beyond a reasonable doubt. Why he pulled off to the side of the road, I would suggest that as soon as an officer talked to him, he was very clear with respect to the officer. He was asked if he was okay, and he said no. And he explained that he was having a heart condition. He explained that he was having, and the officer himself did not appear to be concerned about Mr. Tobey's level of inebriation. In fact, it didn't seem until after they towed the car, found the beer, and most probably looked at his history, his criminal history, that they decided to further investigate.
That's not the record.
Well,
I'm not asking what the officer subjectively thought. I'm glad the officer called an ambulance instead of arresting him.
Well, we have no evidence.
That's what we would hope an officer would do.
We have no evidence that he was driving erratically. We have no
Whoa,
evidence.
whoa. His car is down an embankment 20 feet. We have some evidence that might support an inference that he was driving badly.
But you can equally infer that he had a medical condition. He pulled off the side of the road.
Pulled off the side of the road, over a curb, down 20 feet into an embankment. Have you ever pulled off the road like that?
Against a tree.
I would suggest that if the snow was such that it was plowable,
if he had said, and he didn't, it was snowy and I came off the road, then okay. But he said he parked.
Yes, he pulled off the side of the road and he parked.
At 20 feet down a ditch. All right.
And with respect to the damages that are alleged to the vehicle, the ambulance service said there were no damages that were really visible. There was no deployment.
But there doesn't have to be.
Did you ever park a car against a tree? I haven't.
20 feet down. Maybe we can move on.
Yeah.
Yes. And I'd like to move on to the long and short of with respect to this is the only way to be proven beyond a reasonable doubt is to show that his ability to drive was diminished by alcohol. We don't know when the alcohol was consumed. And you can't know that it was the alcohol as opposed to the medical condition that caused any kind of
alcohol has to contribute to it, right?
You can't speculate or guess as to what it is was the caused him to have whether or not his ability to operate was diminished by the alcohol.
Do you want to argue about that? I mean, I agree that this evidence is in some ways thinner than we see in a lot of these cases. But I don't know that it's really paper thin like you're saying.
Well, I would say that especially when coupled with the closing argument, which is my second
All right,
thing.
so can we talk about the close? Yeah, talk about the
Yes, if I may briefly. The Commonwealth doesn't argue fair inferences. They distorted the testimony. They did this whole playing possum thing. And there was an inaccurate chronology. And this is the last thing the jurors really heard before having to decide whether or not this, like you said, very thin evidence of operating under the influence had anything to do with his medical condition as opposed to the consumption of alcohol. So, having the Commonwealth, the prosecutor, repeatedly say that Mr. Tobey was playing possum and was trying to avoid having his blood taken or having anybody find out that, and they specifically say, as soon as they ask about alcohol, have you been drinking? And he says, oh no, my heart's having a problem. That's not the accurate chronology. The accurate chronology is the first time the police officer came up to Mr. Tobey immediately, he said, what's the problem? I'm having issues with my heart. They didn't talk about alcohol until after the ambulance was called.
By the way, while he's having that heart issue, he's smoking a cigarette.
Yes, Your Honor. But I think a lot of people who are addicted to nicotine have that stress response.
The prosecution concedes a couple of errors in the statements that were made by the prosecutor, and you've identified a couple of them. Yes. But do you have to convince us that playing possum was completely unreasonable on the evidence? I mean, the prosecutor's allowed to draw inferences and to put together a variety of facts. And there are a number of facts here, it seems to me, that do suggest that your client was changing his mind about what he wanted when he was confronted with the next thing that might happen to him. He's, well, I don't want any, I don't want medical attention. Oh yeah, no, I do want medical attention. No, I really don't want medical attention. Aren't reasonable inferences available to the prosecutor from that kind of behavior?
Fair inferences are, Your Honor. And I would suggest that distorting the testimony to suit a narrative, the prosecutor's narrative and the playing possum argument that it makes was not fair. There weren't fair inferences here to twist the facts, the testimony given, to especially when a lot of it was grounded in reality. I mean, the question really in this case was, what caused the impairment? Was it Mr. Tobey's medical condition, or was it the fact that he ingested alcohol? It seems clear that there was some ingestion of alcohol, although we don't know when, and we don't know exactly how much spilled, how much he actually consumed. But in any event, what we do know is he's got some kind of medical history and he's complaining of it.
Medical history, and he says he wants medical attention, but he doesn't stick around to get treated.
No, in fact, I would say that a fair reading of the record is that as soon as he was given a citation, things were calm and things were okay, and he was getting medical care until he was given a citation by one of the officers. And then he became very agitated. It was at that point he decided he wanted to leave. So I think if, a fair reading of the transcript shows that once he saw that he was going to be charged, that he got agitated and wanted to leave the hospital. And with respect to the blood test, Mr. Tobey was given blood tests. For the Commonwealth to suggest, that he was trying to avoid getting a blood test when in fact he'd had blood tests. And, they're playing close to the vest here with respect to refusal evidence. For all the reasons cited in my brief, Your Honors, I would ask that you overturn the convictions against Mr. Tobey.
Thank you very much, Ms. Peterson. You've done an excellent job for your client. We will hear next from Attorney Jang.
Good afternoon. May it please the court. Kristen Jang for the Commonwealth. On the first issue,
pick up actually where your sister left off. I have a grave concern about, I know you say that it was neutral, but to me it seems as if saying he prevented any further testing, so we'll never know whether he had a blood alcohol content, when no one said, A, that the further tests involved a blood alcohol test, and I don't know why they would, for medical reasons. B, he didn't refuse blood tests. He had a blood test. We'd have no evidence about what he was told or wasn't told, but there's blood test results, maybe from 2 tests, but at least from 1 while he's there. If I think that that's comment or a suggestion that he exercised his right not to have a blood test, Don't I have to vote to reverse here?
Well, on that issue, Your Honor, I cite the Aruda case, which specifically says that the statute implicated here only applies to when a state actor, like the police.
Yes, but when you say we don't know about his blood alcohol because he left the hospital, I don't know if it was you personally, it probably wasn't, it was whoever the prosecutor was, but or maybe it was you, but I don't know who the prosecutor was. So, but when you say he refused to take a test, and so and therefore we don't know. The only test that I can see that you might be referring to is one at the request of the police to have the healthcare workers draw blood to test alcohol, because there's no suggestion that he had, for medical reasons, would have been tested for alcohol. So, particularly since it's clearly an error, I think it's an error on your part, or I'm right. I don't think it's fair to say Aruda applies, because the comment was his medical tests that no one ever mentioned and that don't exist didn't go forward. I think we have to take it to mean he didn't get a blood alcohol test, and you and I might, I think it's fair for the court to presume that means, because that's what the Commonwealth would have asked for. So if it's not an Aruda case, don't I have to vote to reverse?
Well, there's also the issue of a fair reply to the defendant's closing. And I just opened up to that page of the transcript. So this is the second volume, page 13.
Just a sec. Let me get that up here.
Has no blood alcohol content. He says it at least 3 times during the defense closing.
Right, that there's no blood alcohol content. That's what I'm referring to. So in the prosecutor, the prosecutor was left to address that, and the prosecutor is entitled to a fair reply to something that was raised in the defendant's closing. So,
why is it a fair reply to say the only reason we don't have this is he refused to test?
Well,
he didn't refuse to test.
Not necessarily. She just said that we can't draw an inference from the lack of.
Okay, but now I'm saying my premise is that although that is the phraseology used at the end, as a fair reply, what she's saying is the only reason we don't know is because he refused to take a test. So we'll never know now. Yeah, I understand that in some sense that's from either side, but it's a response to the defense saying you don't have this evidence, and you don't have that evidence.
We don't.
So far as I can tell, no one ever asked him, frankly, no one ever asked him to take a breathalyzer or asked him to consent to a blood draw, so far as I can tell. Now, maybe they did, and it's just not in the record, which it might not be, of course. But to me, so now why is that fair comment that it's his own action that keeps you from knowing what his blood alcohol was, ladies and gentlemen of the jury?
Because it was a comment on the lack of evidence to show
some sort of okay, but isn't the reason there's a lack of evidence that you didn't ask for one, not that he refused one?
To be quite honest, I don't know why there is no testing in here, because I wasn't the trial prosecutor, but okay. I think the prosecutor's point that maybe there would have been one compelled, but he done as part of the doctor's investigation into what was going on with him. Maybe there would have been one.
He can't be compelled unless it gets quite complicated when it can be compelled and not compelled.
There was no objection to the government's closing argument in this OUI trial, was there?
There was not, no.
Can I just ask you, so I'm on page 18 and 19 where the response is given that we're talking about. Response given by the prosecutor. So 3 times in the defense closing, he says no blood alcohol content. And then the statement is made at the bottom of 18, well, they didn't take blood. Well, that's on the hospital. The hospital, because again, what happened, and now come the paragraphs that your sister objects to. The defendant, when he was told we want to do further tests, he checks himself out. So they can't do further tests on him because he is taking himself out and prevents any further testing to be done. Now, my question because this judge might well think that if that were in fact in evidence, that might be a reasonable response. But was there evidence that he was told they wanted to do further tests before he checked himself out? Where can I go in the record to find that?
I don't know off the top of my head, and I apologize, but there may have been testimony from the officer, excuse me, that appeared at the hospital at first. I believe it was Officer Hines. That is my memory from the transcript, that as to the sequence of events of when he tried to check himself out.
So I'll take a look. I mean, one of the problems which is evident here, which I'm sure you're aware of, and frankly, I credit you for being forthright about the errors that were made. Prosecutor gets confronted with an argument that maybe they're not prepared for in closing. They have to hew to the facts that are in the case. They can't go beyond them. And a couple times she did. And I'm wondering whether this might be another example of that. And I think it's relevant in sort of looking at the closing as a whole. So that's why I'm asking the question.
Understood, Your Honor. And as you just raised, I did point out a couple of places in the closing where it does appear that she went beyond the evidence that was presented. But for all the reasons cited, even in the first part of my brief, the evidence here was pretty overwhelming against the defendant, given all the factors that were raised in the beginning portion of this argument. In addition, you know, her point with a lot of these facts that maybe she did go beyond the evidence at a couple of points. There was a plethora of independent evidence on those 2 points. So for instance,
I don't know, this is to me, well, I said this to your sister, I think there's sufficient evidence here, but this is not the most overwhelming case I've seen. He's talking cogently with the doctors back at the hospital. The note from the medical note is, he says he drank 40 ounces of beer, but seems sort of fully, I don't know what the phrase is it uses. I don't think it says fully oriented, but it says, but, you know, he didn't seem to be, you know, he seemed to be understanding everything I was saying, or, you know, this is not, and then it's sometime later, this fist fight where the guy comes in. I mean, look, 20 feet down an embankment, I parked here seems good to me for the Commonwealth, but this is not, you know, I mean, we see cases where the people are so obviously blotto, they can't, you know, and this just doesn't seem like one of those to me. I'm not saying it didn't happen, I'm just saying.
Sure, but you also can't ignore the observations of him from both the officers and medical personnel about the red bloodshot eyes. One of the EMTs reported that he had slurred speech. He was entirely belligerent at many points to medical staff.
Evidence of slurred speech?
Yes.
I don't remember that. I remember glassy eyes,
yeah, it was
alcohol, strong alcohol later. Okay.
Sure. It was in the medical records. One of the EMTs noted that there was slurred speech, and I did actually cite to that in my brief. It's at SR9.
How many officers testified?
2.
And so the first officer, who was that? That was
Hines.
And it seems to me at the end of his testimony, the question was asked, at some point, was the nurse trying to run tests on him? Do you remember that? Answer, no, I don't remember that. Sorry, I have no further questions.
Then I apologize. I was mistaken that it came in during his testimony. And I apologize that I don't have a citation for the sequence of events there as to when he started to refuse testing. You know, whether that was in response to the hospital staff saying that they were going to undergo further testing.
And you're using testing separate and apart from treatment, because the officer says when they wanted to treat him, he said, I don't need to be treated. But then you specifically asked about testing, and he said, no, I don't recall any question about any evidence, about any discussion about testing.
That was probably what I was thinking of. I was confusing treatment with testing, so I apologize for that. There was testimony, or it was in the medical records, that when the doctor said we're going to have to do some additional treatment, that's when he began to.
Oh wait, I have some testimony here. So at page 135 of transcript 1, I don't know whose testimony this is, but at the bottom, the doctor wanted him to stay and run tests on him, correct? Answer correct. And what was his response to that? He did not want to stay, he said, because it was Super Bowl weekend. And at that point, did his demeanor change? It did. In what way? He became more angry. And when I tried to issue a citation to him, he did not want it. Now, at that point, did you see where he went to? Yeah, he walked in one direction, which is sort of toward the front of the hospital. And while he was walking, was there any injury, blah, 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 and so on.
So Mike, the second officer, I'm looking at the transcript on page 153.
So that was the second, was that the second officer that appeared? Yeah, so the second officer came much later. Just to kind of pull everything together. So the crux of my argument was the Commonwealth has conceded that there were some misstatements of the evidence here, but overall, her theory of the case was supported by the evidence presented here. As I was listing off there, we've got physical indications that this person's capacity to operate a motor vehicle safely was diminished. We have the position of the vehicle when it was discovered. We have his very odd behavior on the scene, saying that I just pulled over on the side of the road. Him saying 10 minutes earlier to the tow truck person that I'm not hurt, and then suddenly saying he's hurt. We have the empty bottles discovered in the car, the receipt from the liquor store just a short time before showing that he purchased alcohol, and also his belligerent behavior at the hospital. All of this goes to the prosecutor's overall theory of the case. As such, even with some of these maybe misstatements of fact, there was no substantial risk here. And if there are no further questions, I'm happy to rest on my brief.
No further questions. Thank you. Thank you both for excellent arguments.
Thank you.
Very helpful to us. The case is submitted.
And we are live.
Good afternoon. Welcome to the Appeals Court. I am Justice Rubin. I am joined by Justices Desmond and Englander. The rules for, we are arguing, of course, by video conference rather than in person due to the ongoing pandemic. The rules for argument are as they are in our courtroom, 15 minutes per side, no rebuttal. We have read your briefs with care, and you can launch right into your arguments rather than the facts if you'd like, because we know the facts, but the time is your own, so you may do with it as you will, ultimately. The next case we will hear is number 18-1691, and we will hear first from Attorney DeBernardis.
Thank you, Your Honor. I represent Stephanie Rojas, as the court is aware. And the defendant's brief focuses on 3 specific statements made by the prosecutor during trial. 1 was in opening and 2 were in closing that were error. And the errors individually or cumulatively amounted to prejudice requiring reversal. I would begin by analyzing number 2 of the defendant's brief in the argument. This is the argument that relates to the comments which constituted burden shifting by the Commonwealth. And these are the comments that the court has read about concerning there was no evidence of allergies and these particular high-heeled boots. First and foremost, I would remind the court that the Commonwealth concedes that the commentary concerning the boots was error within its brief. Why is it error? It's error because it exceeds forceful argument here. It's exceeding reasonable inference. It's actually calling upon the defendant to produce these boots. If they're so important, where are they? Why are they not here? For that reason, the statement is error.
And so the government makes that in response to the defense closing, which was in large part, the reason I didn't do so well on the field sobrieties was because there was snow on the ground, according to she and her witnesses, although that was disputed. But also because I had these high-heeled boots on that made it difficult for me to do the field sobriety test. And so the government, in response to that, said, well, geez, and acknowledges that it was wrong. But it says, well, geez, if the defense to the field sobriety test was the high heel boots, and she's got the high heel boots, how come she didn't bring them in? You agree that was the context of the argument?
Yes.
Nevertheless, you say that it was fatal to the government's case.
I do. I think, well, not I think, I mean, we know the defendant has to produce, it doesn't have to produce anything. The judge even says it, not one iota, not one piece of paper, no physical evidence.
That instruction wasn't enough.
I don't think it was, no. And the reason why I don't think it was enough is because the defendant objected right after the Commonwealth's closing ended, and there was a sidebar. Not only did he object, he moved for mistrial. There was no instruction there. The judge then went into regular closing.
Did he ask for an instruction at that time?
I'm sorry?
Did he ask for a curative instruction at that time?
It was not clear. That was, if the court recalls in the defendant's brief, that was a section of the trial that needed to be reconstructed. And so we reconstructed the fact that there was an objection, that there was a motion for mistrial and the result of those objections, but there wasn't the ability to reconstruct that part. So what we do know as part of the record is that there was no curative instruction and that the judge went into general jury charge. I agree and acknowledge the fact that the regular jury charge included what might be said as a somewhat more specific instruction because the judge said the idea about the physical evidence. However, I think it occurred far away from the offensive statement, so not close in time, and it didn't have enough specificity. I realize it said he didn't have to produce any physical evidence, but it could have related back, as we see in some of the cases, to the actual boots. The judge could have said, he didn't have to, or rather, Ms. Rojas didn't have to produce these boots.
So let's say, I mean, I guess what we're left with is an objected to conceded error, and we have to decide whether it's prejudicial, and that puts the burden, I think, since it's objected to and so on the Commonwealth to demonstrate, I don't remember what the phrase is or something, that it had but slight effect or didn't have any, didn't enter into the jury's deliberations or something like that. And I guess that's what we have to ask your sister about. The burden is on her. Can you make the case, though, that it was prejudicial in light of all the evidence in the case?
Yes, I do think it was prejudicial because when we're talking about these boots, we're talking about the ability to balance. That relates to where the officer said that Ms. Rojas had difficulty walking to the back of the car. It relates to the field sobriety tests and her performance on them. So
but she did hit 2 cars, right?
I'm sorry, she did
collide with 2 cars. Am I mistaken?
There was an accident. There was an accident. Yes.
2 accidents, right?
Yes.
Okay, so this isn't the only, the field sobriety tests aren't the only evidence.
I'm sorry for interrupting. They're not the only evidence, but when the officer gets there, the accident has already occurred. And the officer realizes that she has signs such as slurred speech, etc., and he takes her out of the car. And that's when the boots are relevant. Every observation that this officer makes relate to those, well, not every, but a lot of the observations the officer makes relate to the boots, her ability to walk to the back of the car.
But many of them don't, right? The field sobriety tests measure not only your balance, but in your ability to, I guess your balance and what have you. But it also measures your ability. Say it again, please.
Multitask. There's a piece of this that isn't just about balance.
But it also measures your ability to follow instructions, to do as the officer is telling you to do. Things aside from nothing to do with her feet and her balance, right? Don't stop before I tell you. Keep your hands at your side.
Yes, but in large part.
And the officer commented that she was unable to do those things as well. You agree?
I do agree, but I think in large part, that's where our jury focuses. And I think that when she doesn't fare well in the field sobriety test, that is when the officer takes her into custody and charges her with the OUI. So I think where we're talking about this goes not only for the defendant to say that the Commonwealth's case isn't strong, but it goes to her defense. I couldn't do these tests because of the high heel boots.
Can I ask you about, do you concede that the Commonwealth's case is strong?
I'm sorry? No, I don't.
Okay.
I do not concede.
Can I ask you about the first accident? The second accident is in a parking space or something, right? But the first accident, there is a bumper found in the roadway. Is that right? And there is a car from which the bumper has been torn, apparently, that has no driver in it and isn't moving. Is it parked or is it in the roadway? Do we know the answer to that?
My memory tells me that the car was parked. I hope I'm remembering correctly. That's the impression I got from reading the transcript. I'm not sure if
we don't know whether, when she says he hit me, we don't know whether that accident was with a car moving on the roadway at the time that is now pulled off the road, or whether she is saying a parked car hit her. Is that right?
I don't believe.
Do we know that she's saying a parked car hit her?
I'm not sure if we know that from the record. My recollection, my memory of reading the transcript is that there was not a person in that car.
Well, at the time the police get there. All right. So, I mean, it might be evidence of impairment if you say you were hit by a parked car, since that seems most unlikely.
It might be, sure. If that was the case. And again, I'm not
sure. I will have to look. I couldn't tell. I thought, because it's the bumpers in the roadway. So I sort of
confession reasonably given, counsel.
Anyway, all right.
That's going to be the first thing I look at when this ends, for sure, because that's going to bother me whether there was that evidence in there. My recollection is that no, we don't know the answer to that from the record.
And I'm not saying I think it was a parked car. I had actually thought, I didn't really understand the testimony, because if the bumper's in the roadway, obviously one could tear a bumper off a parked car and it might be deposited in the roadway, but you can also collide with someone in the roadway and the bumper is left there. And I just don't know. Maybe there's not sufficient evidence to even know the answer to that question from what we have.
I don't believe there is. I would, if the court has no more questions about that particular issue, I would point to the issue that is argued first in the defendant's brief, which relates to the statements concerning how much was drank and that alcohol was drank by the defendant through the DCF worker. This is a situation where the defense filed a motion in limine and filed that motion. And if you read the motion in the appendix, it cites directly to limiting, he wants to limit the statements relative to the admission that she and Mr. Rosa consumed a certain amount of beers at his home. And so defense counsel isn't trying to get rid of all of her testimony in any way, shape, or form. He's trying to get rid of the testimony that would be hearsay, and that would be not only an admission by the defendant that she drank alcohol, but how much alcohol she drank.
So
the court
counsel, heard. Here's what's bothering me, and I don't know if you're going to have an answer. Did the defendant move for a mistrial when that happened?
When the statement was made?
Yeah.
The defendant objected.
Yep. Did they move? What I saw in the record indicates that the sidebar was inaudible.
Yes, it was.
Was any effort made, which you can do under our appellate rules, to see if counsel could agree on what was said at that sidebar?
Yes, there was some limited reconstruction. The judge that had presided over this trial had since retired. So there was some work together, and there is a part of the record is a stipulation concerning some of the sidebar. There was 2 sidebars that were inaudible, one that was actually missing. And so we were not able to construct some of the information, but we do know
that I'm interested in is whether when this occurred, someone moved for a mistrial.
I know there was.
I'm asking the question just to put it out there is, if there was no motion for a mistrial at that point, and the judge hasn't yet decided, he's told everybody, I haven't decided whether I'm going to allow that in or not. Okay. I'm a little concerned with sort of the process then, because you've got this, the defendant gets to hold this ticking time bomb and explode it if he loses. But I mean, if he never asked for a mistrial, if he didn't think it was so significant that the case ought to be mistried right then, it seems to me very difficult for the defendant to come in after appeal, after it strikes me that there's an argument here that's sort of like heads I win, tails you lose. I've got this bomb, I can explode at it after appeal, but I didn't even ask the judge for a mistrial in the first case. That's why I'm asking the question. Can you address that concern?
I can, but first, just to answer your first question, I was just looking at the actual reconstruction. What we have is an objection. The trial was a couple of years old, so they did the best that they could at reconstruction. I don't know whether or not there was a motion for mistrial because that is missing. I do think, I understand the court's concern. However, I do think that the issue, he made an objection at that point in time. And I think that's one of those circumstances where easily we can stop the clock and the judge could make a curative instruction. He could tell the jury right then.
Let me interrupt you for a second. The objection was overruled, right?
That's what they reconstructed, yes.
So we have a motion in limine that was denied. We have the prosecutor making the statement arguably in good faith belief based on the denial of the motion in limine. We have the statement objected to, and we have the objection overruled. Doesn't that tend to support the government's case that it was made in good faith?
I don't believe, no, the good faith, I don't believe the Commonwealth had a good faith belief, because when you look at the argument on the motion in limine, the judge says, I'm going to deny it as a motion in limine. And then there's banter back and forth between he and defense counsel that they are going to take it up when the witness testifies.
But
now, when you look,
why do you need bad faith? I thought that, and I'm looking at Commonwealth v. Burse from 1970. It says that a statement should never have been included in the opening unless there was no doubt of its admissibility. Am I wrong about that? Is that not the rule?
I think that here's the argument, is there was certainly doubt about its admissibility. The idea was that when the witness came to testify, there was going to be a voir dire. And if you look at the transcript right before, oh no, am I silent? Can the court hear me?
Yeah, I hear you.
Oh, I'm sorry. I thought I paused.
You're doing great. Keep going.
And right before that witness was called, if you looked in the transcript, I read it again last night, the court sends the jury out, takes a break, and does that voir dire. There's no question about whether the voir dire is going to happen. They launch right into the voir dire. So I don't think it's fair to say that the Commonwealth had a good faith basis to believe that this evidence was going to be able to be elicited at trial. I think the Commonwealth could call the witness and she could testify to what she saw and what she heard. But as to those statements, the Commonwealth was well on notice that that was a live issue.
So this is opening. And
so, and again, I don't think that good faith is required.
What are we to take from the judge overruling the objection?
I'm sorry, I lost my connection for a minute, I think.
What are we to glean from the judge overruling the objection?
Well, I think that's difficult, but I do think that, again, I think this was an opportunity for the court to fix that issue. I think this was an opportunity, one of those rare instances where the court could make an instruction there.
I may be
one requested,
but aren't you saying if there's an objection, the objection was to mentioning this confession, right?
Yes.
Overruled, so preserved claim of error. I don't understand why that cuts in the Commonwealth's favor. The judge erroneously, I would think you'd be arguing, did nothing.
Yes.
And now on appeal, you're raising it. I don't understand this heads you win, tails you lose, that you objected at trial.
And I think that preserves the issue, certainly.
And maybe we'll ask your sister, because I may be just missing the point.
I think that the defendant saw the issue before trial even started. He raised the issue. The judge said, I'm not going to rule on it now. I'm going to do this voir dire later. The Commonwealth was certainly on notice that this was a problem. This was a live issue. The defendant was raising it. He was raising it again. And if you look at the flow of the trial, there was no, are we going to do a voir dire, or do we need to look at this issue? They launched right into it. Everybody knew that's what they were going to do. And that being the case, I think that the Commonwealth was well on notice that this wasn't part of that evidence, that they reasonably had no doubt of its admissibility. That's it. This evidence doesn't meet that standard. And so I do think that this is an issue that certainly was preserved and was error and was prejudicial to the defendant.
We don't know. Look, I'm looking at the transcript and I'm struggling with one thing. There is nothing in here that says objection overruled. Court says, I'll see counsel at sidebar, inaudible on the record discussion at sidebar, and then he just picks up with some other statements. We don't
And
know
that's-
that the objection was overruled. We don't know what was said at sidebar. We don't know what happened, right? Or is it presumed that the objection is overruled because he didn't say anything to the jury?
That's part of the reconstruction. So if you look at the stipulation that's in the record appendix.
Yeah, it says, this is at Record Appendix 14. Your point 3 is defense counsel's objection at volume 1, page 23, line 2, was overruled. That's
Sorry,
in
I
this
missed that.
stipulation. All right, your time has expired, but everyone seems very interested. If there's any more questions, you can. Oh, all right, seeing none, thank you. Very good argument. We will hear now from your sister.
Good afternoon, Your Honors. Kayla Johnson for the Commonwealth. May it please the court. I'll begin kind of where the court left off here with the first issue with the opening statement here. And I would just, in regards to kind of the timeline of events here, going back to the motion in limine, I think once the judge denied that motion in limine to exclude this statement, the prosecutor certainly had a reasonable belief that testimony would be part of the Commonwealth case moving forward. And I think the fact that the defendant asked for the voir dire before the testimony, I don't think that changes the good faith belief or the reasonable belief of the prosecutor.
I got to challenge you on that, counsel. Why is that a good faith belief of the prosecutor where the judge says, which is not at all uncommon, I'm going to wait until we get to that point in the trial, and then I'm going to have then it can be raised and we can make a decision at that point when I've seen the witness. Why is it the judge is literally saying, I haven't decided yet, and the prosecutor then decides that they're going to put in what is pretty charged evidence. She told someone that she had 5 to 6 beers that night. Now doesn't the prosecutor do that at their risk?
Well, I would say first to that is I think the fact that the defendant asked for the voir dire and the judge says, we'll take that up later, I don't think that changes the fact that the judge heard arguments from the parties on the motion in limine, raising the issues, and still denied the motion in limine. So the issues were presented to the judge, and the defendant raised these issues, and the court still denied the motion in limine.
So your point is, even if he denies it and says, I'm going to take it up later, that's sort of a free pass to at least use it in opening. That's sort of what the rule is.
Maybe not a hard line rule in this case, but I think here it's certainly the fact that the motion judge heard the argument and still denied the motion. I think that does support the reasonable belief that the prosecutor would be able to use that testimony in its case moving forward. And I think also.
And do you think this test is reasonable belief or no doubt of its admissibility?
In my brief, I used the case law that says that a prosecutor is entitled to use in its opening evidence that it has a good faith and reasonable belief that it will be admissible in the trial. And I think here
you're aware of the burst language about no doubt of its admissibility, right? Are those
yes,
different?
Your Honor.
But is burst overruled, or you think, or does it just mean that's when you have a good faith belief it can come in, when you have no doubt that it's admissible, and then
honestly, Your Honor, I'm not 100% sure of the way that the language of these cases kind of interplay, and as I mentioned, the case law that I cited includes the requirement that when in an opening statement that the evidence that the attorney has a good faith belief and a reasonable belief that evidence will be admissible. And the Commonwealth's position is that once the motion judge denied this motion in limine, that the prosecutor did at that point have a reasonable belief that the testimony would be part of its case moving forward.
Is that really reasonable, or he had a good faith hope that it would be believed? Right? I mean,
I think. Oh, sorry, Your Honor. Go ahead.
No, go ahead.
I think it at that point it is a reasonable belief that the testimony would be admissible, and I think just the fact that the defendant raised the issue of wanting the voir dire before, and the fact that they were going to perhaps again address the admissibility of this portion of the testimony. I don't think that changes the fact that the judge did hear the arguments and denied the motion in limine to exclude that testimony.
And the judge didn't have to deny the motion. He could have said, I'm taking no action on the motion and we'll wait and see how it plays out. He didn't do that.
That's a very good point, Your Honor, and I think that is important to note because the judge specifically says that he denies it as a motion in limine. And reading the defendant's request for the voir dire later on, the judge says we'll take that up later. So I think it is pretty clear that at that point, the judge, in denying that motion in limine, was saying that I'm not going to exclude that testimony now. And I think the fact that it was addressed later doesn't change that fact. That the prosecutor did have that reasonable belief.
Cite me to the place in the record where the judge says that. If you can't, that's fine. If you can, it would be helpful.
Says that they were going to address it later.
Just where the judge ruled on the motion in limine.
I believe, let me see, it's I'm sorry, I don't have that off the top of my head. Sorry about that, Your Honor. No, I'm sorry, I didn't have that written down. But moving to the second argument, the first that defense counsel addressed here, the statement in regards to the high heel boots. And as in the Commonwealth's brief, the Commonwealth does concede that that statement was error, that it was burden shifting, where the prosecutor said, where are these boots if they're so important, where are they? But as outlined in our brief, the Commonwealth contends that this statement did not constitute reversible error. And the first thing that I would point this court to is the fact that these boots are, well, only kind of but one part of the defendant's case. And certainly these boots, they went to the defendant's ability to balance, but while she was doing these field sobriety tests, but that wasn't the only thing that the defendant argued in support of her case. Specifically, she argued that in support of the fact that she wasn't intoxicated that evening, that there was testimony from her friends that she had maybe 2 beers that evening. There was also significant testimony about the fact that there was a bubble on her tire and that perhaps that had popped before the accident. There was also testimony that the roads were icy and slippery and snowy.
Do you know if the first car was parked when hit or in the roadway, or that's not established one way or another?
As that discussion was happening, I was kind of briefly looking through to see if I could find something, but I don't think that it's clear. The testimony is that the bumper was found in the roadway, but I don't think it's clear as to whether there certainly was no person in the car at the time the officer saw it, but I don't think it's clear from the record what kind of happened. Exactly. I don't think the testimony was very clear as to that first vehicle. Really, all we have is that the bumper was in the roadway and that there was this trail of liquid that was connecting that first accident and the second one. But I don't think it's clear as to whether that vehicle was in the car, or it was in the roadway, or it was parked at the time. But it is clear that the second vehicle was parked on the side of the road. And I think this also kind of leads into the fact that even though this statement by the prosecutor was error, there was significant other evidence of impairment for the defendant on that evening. Specifically, there was evidence of her slurred speech, that she smelled of alcohol, both at the scene and hours later when she was interviewed at the police station. There was testimony as to her red and glassy eyes, that apparently she crashed into the first car, whether it was parked or driving, but she did leave that scene and go to continue driving and then hit another parked vehicle. And there was also testimony from her friends that she did in fact drink alcohol that evening. So I think all of this evidence together does support the argument that although the statement was error, that it was not reversible error.
Can I ask you something I should know? I'm trying to back in my head, I'm still thinking about the reasonable belief that this testimony would come in of the confession of drinking the beer.
Mm-hmm.
The motion in limine was based on Miranda. Is that right?
Yes, because there was testimony that she was given her Miranda warnings at the scene, but
by the police, but not by the DCF worker, a different person, different agency, talking about something completely different. And the judge later on, I think probably correctly, it's not appealed anyway, or cross appeal, whatever, I don't know what you do, says, oh no, the old Miranda warning is not, like, doesn't cover this. You needed a new one.
That's correct.
Did the judge explain why a voir dire was necessary on that point? Was this all set out in the motion in limine so that nothing new was introduced at the voir dire that the judge didn't know about, but the judge just changed his or her mind? Or you see what I mean? I'm just trying to figure out, at the end of having won the motion in limine and being told, but there will be a voir dire, what a reasonable person would have thought about this evidence.
And
we have, I think we have the papers,
point.
right? So
I'm actually staring at it. I just reread it. I don't think anything that anybody said is inaccurate, but Judge Rubin is getting at the same question that's on my mind. You say the prosecutor had a reasonable and good faith belief that it was going to go in once this was denied. I see the argument being made by the defense counsel, look, she wasn't Mirandized. I see prosecutors saying two things. One, she was Mirandized at the scene. And secondly, that Mrs. Miller says, Mrs. Miller being the DCF person, that it's her practice to also Mirandize, but she doesn't recall if she did or not. That's essentially the same testimony that came in when the judge decided to exclude it. And so what reason would counsel have to believe that that evidence is going to come in based on the evidence that they then knew? And I'm asking about from the prosecutor's perspective.
Do you mean like the difference from the motion to the testimony at the voir dire?
When he knows his witness is going to say, I don't remember if I Mirandized her, but that's my practice. Why would he believe that that evidence is going to come in, the 5 to 6 beers? What would be the argument?
I assume it would be that the Miranda warnings from earlier would
carry the day.
Yeah, I think that would be the argument. And
is there
perhaps the fact that
case law on the difference between talking to a DCF person and talking to the police, right?
I'll be honest, this isn't an issue I really kind of delved into before this case, but it would be something I would have to look into. And if the court would like, I would be happy to submit something in writing on this issue because it does.
I think we can look at the law.
At the end of the day, the judge said the motion in limine is denied, and whether or not there'll be a voir dire, we'll discuss later. He didn't say it's denied, but we'll have a voir dire. That's not the record. The record was it's denied, and then when there was a request for voir dire, the answer was we'll take that up later. Not whether there will be a voir dire, whether there won't be a voir dire. We'll discuss it later.
And that was my interpretation as well. Sorry, Your Honor, if you're continuing.
In any event, the issue there now would be there was other evidence that she had been drinking beers.
Yes, right? and I think that's an important point, that even without this testimony later coming in, I think it's important that there was testimony that she drank at least 2 beers that evening.
And the cases tell us that's an important point, whether or not this was cumulative evidence or whether it was kind of standing alone. And in this case, I mean, yes, there's no other evidence that it was 5 or 6 beers. This is the 2 beer defense, which we see so often.
And I would agree with that point. And I think I would
What is your argument that the 5 to 6? I think Judge Desmond is getting at this, but I'd like to hear you put it together. What is your argument that the 5 to 6 beer statement in opening is not prejudicial enough to require a new trial?
I think it's because there was testimony, there was other testimony that she was drinking that evening. I think all the evidence that I previously outlined, the slurred speech, the bloodshot eyes, smelling of alcohol, I think the weight of the evidence supports the fact that this statement wasn't prejudicial, and the fact that the judge instructed the jury 5 times that anything that was said in these opening statements were not evidence.
Can I just say, can I ask a question about, just back to what Judge Desmond asked you, because I'm now looking at the same page of the transcript. The judge says, I'll deny it as a motion in limine, but it would be subject to objection as the case unfolds. Isn't that reserving the question for them? Then it's true, the attorney says, can we do a voir dire? And he says, well, we'll deal with that when you object later. But he, I don't know, I read that. Do you not read that as sort of leaving open? You'll raise an objection, maybe you'll ask for a voir dire and I'll allow it, whatever. It's, I mean, what's the point of saying it's subject to an objection later, except to say, but I'm not, this is my final decision.
Well, I realize my time is up. I'll briefly answer. Something that came up in while I was looking at this case was in 2013. So this was before the case of Grady that said that you didn't have to object again to something that was raised as in opening statements.
But why tell them it's subject? Everyone knows, right? Why, by saying, don't you take the statement, of course, he doesn't say, of course, he says, I'll deny it as a motion will be, but it would be subject to objection as the case unfolds. That's not just informing him, if you want to preserve your rights, you have to raise it later. He's saying,
well,
I'll hear an
I
objection.
think, yeah, I think in one sense it is kind of just saying that the defendant will have to raise the issue again if they still have a concern about it. I think where the judge denied the motion in limine, the judge was saying that he was not excluding the evidence at that point, and that if the defendant still had a problem with that later, when the Commonwealth sought to introduce it, that the defendant could raise the issue again.
And frankly, there was no exclusion or there was no introduction of the evidence because, you know, as the judge repeated, it's an opening statement, which is not evidence.
Exactly, and the judge did repeat that statement, not only before, but
it's a massive confession. I drank 5 to 6 beers is the end of the case.
I think there is weight to that testimony, but I think in the face of all the other evidence that was presented, I don't think it kind of has the impact that it would have standing alone. I think where there was testimony that the defendant was drinking beer that evening and had 2, I don't think, in conjunction with the rest of the evidence as well, I don't think that this statement would have as much of an impact as in the face of all the other evidence.
Could the defense have argued, listen, the Commonwealth told you you were going to hear from this witness who was going to tell you she drank 5 or 6 beers. Where was that evidence? We never heard from.
You mean the defendant?
The defendant made that argument to the jury. Listen, the government promised you were going to hear from a witness who's going to tell you.
Whoa. And you'd have said, the Commonwealth would have said, Your Honor, we'd like to bring in a rebuttal witness. They can't use this shield as a sword. She did say it. She wasn't Mirandized. You've introduced this phony narrative that we didn't have the evidence. We do have it. It just wasn't Mirandized. And the judge would have said, of course, you can bring it in.
I'm not sure. I think in those circumstances, Judge Desmond has done this more than me, but the judge might say, no, you brought this one on yourself. You put something in an opening you couldn't get in. That's your tough luck. But well, anyway, that's going a long way down the road.
Yeah, that's a road that didn't.
Yeah, I'm not sure I have an answer to those points there. But if there are no further questions, I know I'm well over my time. The Commonwealth will rest on its brace.
Due to our questions. Does anyone have anything else?